31.
Yes, Lordship. In this case, I am appearing for the Resolution 2 and 4. On last occasion, Lordship, we could not appear. And Lordship will speak the matter for hearing. Lordship, we require to file our affidavit in opposition in this case.
Okay, I'm for the petitioner, Lord.
2 weeks time, may be allowed.
2 weeks time.
Lordship, the interim order may be continued, Lord.
What is the interim order?
Lordship, their pendency of the,
During pendency, regular salary may be paid. That was the.
that was like,
You're receiving it.
no, Lordship. the
Lordship, we
salary-
are filing necessary application along with the affidavit.
How much time you require?
2 weeks.
2 weeks. Any objections?
No, Lord.
Mr. S.C.K.L. Learned Counsel appearing for respondents 2 and 3, 2 and 4.
Sure.
Prays for 2 weeks time to file his counter affidavit. There is not objected to by M.S.K. Talukdar Learned Counsel. Petitioner. Let the matter be listed up. Okay.
Primordial passed on 21/12.
Do you stop his current salary with there's a direction?
Lordship, yes, Lord.
You
There is
have
a
to release that.
Yes, Lordship, we are filing necessary
No,
application.
no, your application is different. You have not applied for vacating the interim order.
No, Lordship, that we are filing, Lordship, because on last.
Mr. Counsel, until you file, until this order is vacated,
Yes, Lordship, that is correct, Lord.
you have to pay. This order was passed on 21/12.
Yes, Lord.
Then the interim order dated 21/12/2023 is reiterated. Petitioner will be paid his current salary from the month of September 2023.
September 20.
September, Lord.
2023. The respondents will ensure that the interim order is carried out.
Much.
Much obliged, Lord.
Because I am paying for listing one revision matter, Lordship. We have to list any date in the next week, Lordship.
What is that matter for?
Regarding payment of salary, Lordship.
Admission.
My lord.
Payment of salary, let us have it in March.
The last week of February, Lordship.
No, 4th of March. 4th of March.
Similar, Lordship, non-payment of salary listing.
4th of March.
Much obliged.
Wait, please, Your Lord.
Yes.
My lord, in item number 1, my lord. One affidavit in reply has been filed yesterday, my lord.
Huh?
One affidavit in reply has been filed yesterday, my
Bring it.
lord. My lord.
May it please your lordship. With consent from the other parties, I beg to mention item number 12 for adjournment.
Item number
12.
12. Item number 12. You are for the
Respondent,
respondent.
2, 5, and 6.
You have taken consent of the petitioner.
Yes, lordship.
Okay.
Lordship may fix this matter after 2 weeks.
At the request of MS So-and-so Learned Counsel appearing for the respondents, matter stands adjourned for 2 weeks. It is submitted that consent of the counsel for the petitioner has also been obtained. List accordingly after 2 weeks.
Like Lord.
Yes.
Please, Your Lordship. First of all, I beg to mention item number 9. The conducting, I'm for the petitioner. Conducting counsel is not well, so the matter may pass over for a week.
You are appearing for the petitioner.
Yes, my lord.
Your name, please.
B. Doctor.
B.
B. Doctor.
P. Dr. Learned Counsel for the petitioners. Appearing for the petitioner submits that who is the conducting counsel? Who is the conducting?
NC does.
Makes a prayer on behalf of Mr. N.C. Das, senior counsel,
Yes, sir.
that the conducting counsel is unwell and therefore adjournment is sought for. The matter stands adjourned for 2 weeks.
1 week.
1 week. Let it be 2 weeks. Yes.
Lordship. I love this.
May it please your lordship. Lordship, I beg to mention for listing lordship, listing of a writ petition lordship.
For
Next- for admission lordship. Next
Fourth.
week,
4th March. 4th of March.
on February lordship.
What matter is it?
Lordship, this is non-payment of pension lordship. And the grounded my service has not been regularized. The petitioner has not received anything lordship after retirement lordship.
All right, 28th of March, February.
Obliged.
May I please, Lord. I beg to mention one contempt matter, Lord. It may be listed on next week any day, Lord.
4th of
December.
March.
4th of March.
May I please,
Okay.
Lordship, beg to mention for listing of a writ petition for admission.
4th March.
4th.
Perhaps in this letter, item number 2, Mr. R. Majumdar is there, Lordship, but maybe taken up after some time, Lordship.
No, what are these matters? Where is he?
R. Majumdar, 229.
229. In that case, my lord, I am for petitioners.
One to you. Okay. Yes,
Lord, in item number
Hmm.
424567
Hmm.
and 8. I have appeared for petitioners, my lord. And already Learned Council has submitted that some of them has got service with a with a my lord undertaking that they will
Prospecting.
withdraw the case, my lord. I have written to all of them, my lord. And one of them has replied that he has not got the job. Now, my lord, at this stage, my lord, I pay for 2 weeks or 3 weeks time. By the time I can say, my lord, who has got it or not.
This kind of arrangement, you make it outside court. Why are you troubling the court?
No, my lord,
You
that is
are
why I'm
prosecuting-
adjourning, my lord. I am paying for adjourning.
Adjournment of 2012,
Yes,
13,
sir.
14 matters.
Because I have written to them and
You have written to whom?
all my petitioners, my
No,
lord.
we will close these matters. If you have any grievance, you come back again.
No, one chance, my lord, 2 weeks time, only one chance.
What 2 weeks time?
Because some of them,
When have you written to them?
my lord, I have written.
What about the writ petition by the state?
Lordship, in that particular writ petition, Lordship, Mr. R. Majumdar is there. And perhaps on the last occasion, your Lordship has directed to get the details of those litigants who have been accommodated, and that record was supposed to be produced by Mr. R. Majumdar.
Please call him.
Lordship will take up after some time.
Yes, after some time. We'll take it after some time. You find out.
Lordship, my senior is on legs. Can the matter be passed over for the time being?
Who is your senior?
Mr. Ndeka.
Who's for the petitioner? Yes.
Martin is also on legs, Lordship. After the matter for timing.
You are there. Take the opportunity to argue the matter. You argue the matter. What is your case? Let us hear.
Lordship, Lordship, I'm the mother of the deceased late Ganesh Teron, Lordship, and he died in harness, and he was Lordship, he was married to Maya Teron in 1985. Later on they had three kids. Later on, the wife left the deceased. She abandoned the deceased. She went away along with her three kids. So, Lordship, for a number of years, there has been no communication with the wife. I have no communication with my daughter-in-law. So, Lordship, and since he died in harness, since my son died in harness, Lordship, I had applied for the pension, Lordship, and accordingly, succession certificate was granted by the court below, learned court below, and I received an amount of 20 lakhs. Now, Lordship, may come to the superannuation benefit fund scheme. Lordship, accordingly, there is a superannuation benefit fund scheme in which I had also applied for it, but the respondent authority, that is the IOCL, they are stating that they need another succession certificate for it.
Where is that?
Lordship, the succession certificate for the 20 lakhs is in Annexure 9, Lordship, page number 33. But recently, later on in Annexure 12, page number 64, the IOCL has said that I will be needing to submit an succession certificate for the pension amount. Now, my grievance is there, Lordship. I had earlier submitted the succession certificate proving that the deceased is my son. So again, the IOCL is asking me to submit another succession certificate for this
Because-
superannuation benefit fund scheme.
No, because in the succession certificate, page number 35, you come to page 35. This is your succession certificate, isn't it?
Yes, Lordship.
This is the succession certificate.
Yes, Lordship.
So in this succession certificate, you will find the succession certificate given in respect of which debts.
Uh,
It is written on the right hand side. PLI,
yes, sir.
cafeteria,
Yes, sir.
EDLI. So all the claims which you have raised
Yes, Lordship.
before the court in the succession certificate has been given in respect of that.
Yes, Lordship.
Now, what are you claiming?
No, Lordship, the SABF, Lordship, the superannuation benefit fund scheme, Lordship. That is the pension, that is the,
And
that is the pension amount, Lordship, the SABF pension amount. Which is not pension, Lordship, Lordship, we
what
have
is,
to.
what is the stand of the respondents here?
Lordship, we have filed our affidavit.
What do you say?
In Lordship, in page number 79, the deceased before his death has filed nomination. Those are entitled for the benefits after his death.
But Lordship, the nominees, they are never heard of, Lordship. And if we go by the evidence like section 10.
Petitioner is the mother. Petitioner is the mother.
Mother, yes, Lordship.
And the deceased also had his wife and children. So he's given nomination in their favor.
My lord, actually, my lord, what happened, my lord, they got married in 85, my lord. From 83, my lord, they left, my lord. They have not found, my lord. Accordingly, my lord, when after the death of the, my lord, son of the petitioner, my lord. So for the, my lord, 20 lakh some amounts, my lord, other benefit, my lord. For they have, my lord, asked to file a succession certificate, my lord. Accordingly, succession certificate has been produced and paid to her, my lord. So, my lord, later on, my lord, there is another, my lord, pension scheme is there, my lord. That pension scheme is, my lord, if this wife is, my lord, no longer, my lord, touch with the family for last 7 years, my lord. Maybe they are alive, but nobody knows, my lord, whereabouts of them, my lord. So accordingly, this mother is entitled, my lord.
No,
And they have said that I have to produce a succession certificate for the pension. Pension to success certificate not required, my lord.
no. Pension will be first, there's a nomination
My
for the
lord.
wife.
My lord.
Nomination for the wife.
So she is supposed to come by 6 months, my lord, according to their rules, my lord.
And
See-
what does the rule say?
Now my annexure 12, my lord, last page of the petition, my lord, they have sent a letter to me, my lord.
Yes,
The refinery authority sent a letter to me, my lord, when I asked for the pension, my lord, their annexure 12, page 64, my lord.
60.
That has been under challenge, my lord. This is addressed to me, my lord, in persons to my request letter, my lord. We received your letter dated so and so, whereby you have requested to release a regularization of the pension benefit arising on account of death of your son, Sri Ganesh Taran, employed on so and so in your favor. In this connection, we would like to inform you that ordinarily in case of deceased merit employee,
Just 1 minute, 1 minute. Please,
my lord,
yes.
in case of disease merit employee, the SAB superannuation financial benefit, pension benefit are released in favor of the spouse only, that means wife. The spouse is required to be contact the office authority within 6 months from the death of her of an employee and completed the necessary formalities in this regard.
However, in this case, your deceased son, late Ganesh Teran, his wife Srimati Maya Teran did not come forward for settlement of the terminal benefit of her late husband. It may be pertinent to mention here that Guwahati Refinery authorities also issued various letters to her in this regard. We would like to inform you that since the claim SABF/pension benefit of late Ganesh Teran is prima facie not free from income branches, this same can be released to you only if you produce a succession certificate in respect to SAB/pension, my lord. They have said if I, my lord, produce a succession certificate, they will release, my lord. In case of pension, my amount is not fixed, my lord. So it is not possible to get a succession certificate if amount is not fixed, my lord. And if they inform, my lord, that if I get a total amount, then I can produce a succession certificate. For monthly, I cannot, my lord. That's why, my lord, if they have released the earlier amounts, my lord, to me, 20 lakh something, now they also, my lord, on that basis, they
What
can
is the
release, my lord.
pension amount? You are releasing a lump sum amount.
No, that is different amount.
Also, actually, as per our scheme, in case of death, female spouse, spouse is paid. Now the problem is.
Where is the scheme?
Yes, I have got this scheme. Superannuation Benefit Fund Scheme.
Uh,
Have a look.
My lord, I admit my lord, spouse is entitled. He's a class 1 here. After spouse
The
is not
problem is,
longer, my lord, then mother is, my lord, entitled, my lord.
Is there any description of a family under these rules, under
I
this
think-
scheme?
I don't have a copy right now. Have a copy here. Succession certificate এর problem আছে না? Opposite party also. There is another problem with regard to the succession certificate also.
Hmm.
Because the address, our claim is that wife of the deceased has deserted him in the year 1993.
Yes.
But in the succession certificate, The address one is the earlier address.
Sorry, madam, I was on Lex.
Yes,
One of the issue is here whether the mother would be entitled to the pensionary benefits. Because the others, in respect of which the succession certificate has been issued, my lord, that has been paid, there is no dispute on that, my lord. Now, the pension, so far as the pension or whatever that SABF we call it, my lord, superannuation benefit fund, that is payable under a particular scheme, where the scheme excludes the mother, my lord. It is only the spouse who is entitled.
it does not exclude, but
It excludes, my lord. If
Is
I may
there a
respectfully say, my lord,
is
it
there a
excludes.
specific exclusion?
It is only says that it is only the spouse, my lord, because I
No,
don't have a copy of
Female
that.
spouse.
Lordship sees that options R1, R2 and R3.
Hmm.
Now, R2 and R3 is not possible. Why? Because there is no question of R3 is regarding compassionate appointment.
Hmm.
So that is out of question now.
Hmm.
And so far as R2 is concerned, my lord, that is also not possible because for that, the entire PF, gratuity, whatever has to be refunded to us.
The only option is
Only
R1.
option is R1, and if your lordship reads R1, my lord, it says the spouse has to opt, my lord. In any case, my lord, the sons are alive in all probability.
There is no definition of family.
There is no definition of family.
Yes.
Now, my lord, one more thing, my lord, I'd like to point out. If your lordship kindly sees the notice by which service was deemed to be served, my lord.
Service?
Service was deemed to be served on the wife and children before in the succession case. My lordship kindly turns to page 26 of the writ petition.
26.
My lord, it is the case of the mother that the wife has deserted the husband, my lord. I mean the son, deceased. Lordship kindly takes a note at the address, my lord.
Hmm.
Legal notice so and so, Maya Teron, wife of Ganesh Teron, Bijoy Teron, Ajay Teron, son of late Ganesh Teron, all are residents of Nunmati Vishnu Rabhapanagar.
Hmm.
This is the address of the Guwahati refinery.
Hmm. So,
So it is their case that they are not there, my lord.
but what about the records of the corporation? You are unable to find out?
We are unable to find out.
They have
because
also issued notice several times.
we are unable to find out. Lordship sees page 79, my lord.
Yes.
This is the nomination form.
3 sons.
3 sons. Even if we assume, my lord, for a moment that there is a divorce, the sons do not lose their right, my lord. Just like the mother is a class 1 heir, the sons are also class 1 heir. And because the mother has already received the everything, my lord, the gratuity, PF, everything.
The whereabouts of the son are not known.
Not known to us.
Yes, Mr.
My lord, they have admitted, my lord, by Annexure 12, my lord,
Hmm.
that you provide a succession certificate, we are ready to give you, my lord. That plea was not taken, my lord. That I have challenged, my lord. Without succession also, they can provide the pension. That question is not coming, my lord. This is entitled or not, because she is a class 1 here, my lord. If her son, my lord, who is the employee of the, my lord, my lord, corporation, my lord. So, my lord, he is no longer, I have stated, and in the notice, my lord, paper cutting, my lord. Because, my lord, I do not know where they have gone, because last address was my address. which I have shown in the paper cutting, my lord. And it has been the provision of the CPC, my lord. I have to give a paper advertisement notice when the person is not found in the address. I have to give that address, my lord. This is, my lord, cannot be disputed, my lord. I have given the same address. If I know the address, I could have find out them also. So after duly published notice, my lord, they have not responded in the, my lord, succession case. That means they are not found, my lord. They are not, my lord, available. In the,
If you're applying 108,
my lord.
then there has to be some order at some level.
That is the, my lord, succession certificate where I will, my lord, last from the 93, they have been not known by any person. Even I have no knowledge, nobody has seen, my lord. Maybe they are living somewhere, maybe. But nobody has able to find out their location, but they could not be located, my lord. Now, how they will let, my lord, if my lord pension is released to me, my lord, I'll give the bond security, whatever, my lord. If they come forward, my lord, later on, I'll ready to return, my lord.
Now, how will you return once it is given to you?
My lord, their stand is not that, my lord. My learned team has, my lord, taking a different stand as of now, my lord, but notice, my lord, is different. They have asked me to give a succession certificate. Not, they are not disputing my entitlement. Lordship, come to the notice page 64, my lord. The letter communication issued to me, my lord. The second paragraph, my lord. They have specifically said, my lord, if you able to, because earlier, my lord, other benefits, my lord, retirement benefit, 20 lakh something, my lord, have been paid to me on the basis of succession, my lord. Now they are that you provide a succession, we are going to give you the pension. My lord, only thing is that in case of pension, succession certificate is not possible because pension amount, it is one-time pension, that amount, that is different thing. Monthly pension, monthly, every month I have to go for succession certificate, my lord.
What does R1 tell, R1 say? R1 is for 15 years
15 years
or the lifetime.
or the lifetime, whichever is there. My lord, issue here is, number one, my lord, if my learned friend has completed, my lord. Because the first issue will be whether, my lord, that I do not dispute that letter has been issued by an officer. Number one issue, my lord, the pension, it has been held by the apex court that the pension is not part of one's estate. So whether a succession certificate can even be granted for pension, my lord, that is doubtful. I have my reservations.
No.
Because I have a judgment. I have a judgment.
These reservations, you will have to bring it to.
I have my judgments, my lord.
Hmm.
1991, 1 SCC page 725, that case of Violet Isaac, my lord.
Hmm.
There the apex court has said that succession, the pension is not part of one's estate.
That's right.
A person cannot write a will that my pension will go to so and so. It is family pension is payable to the spouse.
Hmm.
It is 1991, page 1 SCC page 725, my lord. If I have to pay, my lord, IOCL will have to pay either to the
No.
wife or.
The question is not about
Exactly.
whether it is a part of one's estate or not an estate. Question is, this is a scheme. This is an amount which is required to be paid to the spouse. Spouse is not here.
Spouses.
You have no information.
No information.
Nominees are not there. What happens to the amount? Are you entitled to
It
withhold?
remains, my lord.
Are you entitled to withhold the amount?
No, my lord. No, my lord. Not a question of withhold, because ultimately it's not the contribution of the employee.
No, that's a different
Contribution has gone, my lord. I am not withholding anyone's money, my lord.
No, it's not that. It's a question of the mandate of the scheme. You are supposed to
Yes,
give it.
my lord. Provided.
There is no interpretation what happens if either of the spouse is not available
My lord.
under this scheme. So that is the question to be decided.
Exactly. So if no one is there, suppose mother is not there, father is not there, the employee dies, my lord, then there is no question of withholding. We need not pay to anyone, my lord.
No, that's a different issue. But here somebody is there.
Somebody is
Legal
there.
heir.
First and foremost, my lord, lordship will have to decide that she is entitled under this scheme. If lordship holds that she is entitled under the scheme,
No, she is prima facie, she is not entitled. But the question is, you are unable to find out the status.
we are unable to find out, my lord.
You have to your scheme says within 6 months.
Within 6 months.
The
The
beneficiary
death
has
of
the
the employee. Now, this ordinarily would be applicable, but for on a case-to-case basis, some efforts will have to be put in by the IOC to find out what is the status.
That is there, my lord, but the question what my learned friend lordship has, what has
And
fallen from your lordship.
this letter which you have issued also, was in 2019. And if you think that this is not the proper authority or the proper manner to issue a letter, this has not been or
I will not say
substituted.
it's not the proper manner, my lord. I would say that may not be the correct proposition of law, my lord. Because if my learned friend produces a succession certificate, my lord, I have got no other option. I will have to pay
But
unless someone challenges it.
let them give the amount, my lord, fixed amount. I will get this
My lord,
much of
from
amount.
where will I give the fixed amount?
Because succession, really record a fixed amounts, my lord. On that basis, they pass will order to release the amount. Because pension is variable, my lord, month to month. Like my lord,
In Violet, Violet, the widow was alive.
Yes, my lord.
The widow was alive. And
Here I think, my lord, here
contrary to the nomination, there was a will.
will, my lord. Correct.
So there the court said that it goes by the rules.
Exactly. my lord. So it cannot be bequeathed, my lord. It is not a. So if it is not part of one's estate, my lord, whether the law of succession will come in. Because lordship knows there are n number of judgments which says that if mother is excluded from the definition of family, then she will not get it. I remember, my lord, one case of the Punjab police, my lord, where a constable had passed away. And the legal heirs were not there. Only the mother and father were alive, my lord. And exercising 142, the apex court had directed that let it not be a precedent, it may be paid to the mother. Not the mother, the parents, my lord. But the law was held that if the family it is excluded, family includes someone, then you go by the definition. So here also, my lord, in my respectful submission, it is the spouse who is entitled. And 108 also, as has fallen from your lordship, my lord, 108, there is no declaration.
Yes, Mr.
well, let them, my lord, file that I am not entitled, but affidavit, my lord, because they are asking me to.
You are not entitled prima facie looking into the scheme. Scheme talks about spouse. Doesn't include
My lord, when my lord,
family.
nominee
wife.
has to be put, definitely they will put the wife, my lord, definitely, my lord.
Huh.
So if she is no longer alive, my lord, so it is benefit to the family member. So
No,
whether the mother is included in the
No,
family or
no,
some
no,
pension is to
Your
benefit to the,
interpretation must be based on some law.
and whether mother is dependable on his son or not, if he could have a leave, my lord. That is a, my lord, which
This
will
is
come, my lord.
strictly an interpretation of the scheme. The scheme is very clear. It's for the spouse. The CCS pension rules don't apply here. If you go through the scheme, if you have a copy of the scheme,
My lord, I have the copy, but that the R1, R2, I am not getting, my lord. I have the scheme, but here no spouse is, I have find out, my lord. There's a 2007 scheme, my lord, newly printed.
I don't know.
Let me provide a copy of the scheme, my lord. Let me know, my lord. But in my lord, this
There's no
scheme, my lord.
number in the scheme. So it's that yellow flag. You can have a look.
My one is, my lord, super benefit fund scheme, my lord. This one, it is different one, my lord. That is only in
Correct.
English.
I don't.
Here is my, I have seen part of, is in Hindi, my lord.
There is another judgment, my lord, 2016, 16 SCC 229, where also it says that when the scheme bars, my lord, para 18, 16, 17, and 18,
What is that citation?
2016, 16 SCC page 229, my lord. Neetu versus Sheila Rani.
Yes.
Here, of course, my lord, in paragraph 14, the family is defined.
The justice calls judgment.
My lord?
Justice calls judgment.
No, my lord, Dave. Family is defined. There also, lastly, it says that for the aforesaid reasons, in our opinion, the High Court committed an error by giving a direction that the respondent mother should get 50% share in the pension. So that is the only hurdle, my lord. Otherwise, my lord, if we have to release, my lord, we have to pay. Either it goes to him or the mother, the wife. So we are concerned with this scheme, my lord, because if lordship gives a direction, my lord, then it will open the floodgates, my lord. Indirectly, the scheme is being set aside, my lord. That is my only concern. Because the rest of the money, admittedly, she has got it.
Is there, my lord, female, the spouse is there, even children are also not entitled according
Yes,
to them, my lord.
Yes, children are not
If,
entitled.
my lord, it is to be interpreted, my lord. Children are also not entitled.
Not entitled.
Not
Then
entitled.
how they depend upon is entitled as per the law, my lord. We have to challenge this scheme, my lord, if they,
Yes,
my lord.
you have to challenge the scheme. Because
Plain reading of the scheme, you are not included. Notwithstanding that, some amounts have already been released.
no, my lord, that is not part of the pension. That is the employee's contribution.
Even that also I am not entitled,
That
my
is also
lord.
he is not entitled, my lord.
If
Because
he
he has
says
to
so,
share
my
it.
lord.
That is what we said.
He has to share it, my lord.
But
He might
this-
have received it, my lord.
This scheme, wording of the scheme, prima facie does not include the,
My
there is no definition of family. It's
My
only
lord.
the spouse.
My lord, let me have a revisit my these documents, my lord. I'll take a photocopy from my friend, my lord, then I'll next month, maybe some other day, my lord. Because that is not known to me. I have challenged the only their letter, my lord, their communication. You are asking me, my lord, provide a succession certificate. I cannot. That is my case, my lord.
This scheme is also by virtue of an
Because
agreement.
they have
my lord.
not, in the affidavit, they have not said I am not entitled. Now my learned friend is saying, my lord, the authority is not saying, though my learned friend is bring the authority, they have not said, my lord, I am not entitled.
No, there is an averment saying that you are not entitled.
কখন photocopy
I'll provide him with a copy, my lord. Let him consider if he wants to.
সেই provision তো নাই এনেক্সা
নাই
নাই
এখন পুরোনো মোটাটা আছিলে
এখন নাই এখন কিন্তু সেই নতুন
Okay, we'll take it up next Tuesday.
next Tuesday.
Third learned counsel for the parties. At the request of learned counsel for the petitioner, just as yet, we listed again on Tuesday. 13. 13.
my lord. 13.
Lordship has fixed it on 13th, my lord.
13.
My lord,
I'll give him a copy, my lord.
my lord may not be on 13, my lord. 13, my lord.
Why?
Possibly I have to go somewhere for other case, my lord. If matter is listed, my lord.
No, see, once we open a matter, we'd like to close it
My lord.
because there's no point in fixing, because plain and simple, there's no definition of wife. We can close it today. But because you wanted to go through the scheme, we had given you some time.
Maybe on 12, my lord, then.
12th, it is a miscellaneous day. So this will require some hearing. You want it on 12th, all right, 12th, list on 12th. 12th,
My lord.
12th. Mr. N. Deka, if you
Did you?
I love it.
Oblige.
Here I was required to bring on the details of the persons who have been accommodated as teachers and tutors. Around 4 or 5 have been identified in different districts who have joined. I'm waiting for the report on the others. 2 weeks time, my lord, would perhaps, that would bring down quite a bunch of the petitioners from the.
No, but this is a writ petition by the state.
Yes, my lord. What had happened is we had gone to the tribunal. They had gone to the tribunal. There were 2 batches of cases. Lordship will find the other matters are all someone versus the state. So they had challenged their, when we said that they were illegal appointees, that was what was challenged. Now in one group, for the same district, the same selection process, the tribunal held that yes, they are legally appointed and they should be given all the benefits. That is where the state has filed a writ petition against the order of the tribunal. And the others, the tribunal had rejected, saying that these are all illegal appointees. So those petitioners have filed their own writ petition against the same conclusions. Now, when the screening process had taken place, quite some of the petitioners have joined in the screening process and many of them have been accommodated as teachers or tutors in various posts, and they've given up all their past claims. That is what I had sought from on the last date to find out the actual details of all those petitioners, because they would now not be interested in pursuing the writ petition perhaps. And for us, we can give up our grievances against those petitioners. So therefore, my lord, I have now got information today morning with regard to around 2 or 3 of the petitioners who had actually joined the services. The rest, the department is still verifying from the schools. So she could give me just 10 days or 2 weeks time, my lord. I'll have the list prepared. We can cut down the litigation.
Matter stands deferred by 2 weeks. On the submission of Mr. R. Mazumdar, Learned Counsel, appearing for the Education Department in WPC number.
I been the
Hmm?
It's on 7624.
7624 and 2981
7624 and 2981.
of 2015.
And for the respondents where the state is the petitioner, and in all the other matters where states the respondents. It is submitted by Mr. Mazumdar that some of the petitioners have been offered appointments and they have given up their claims and have joined in their new places of posting. However, the complete details are not available, and he therefore prays for time. Similar prayer is also made by Mr. Sahu, Learned Counsel, appearing for the writ petitioners
In item
approach
number,
this court
item
against the state. The matter be listed again on 27th of February. 27th.
In fact, my lord, in the item number 5, the first writ petitioner has joined and given up her claims. So
You
that
give
is how
the
we'll
list.
try to identify. Yes,
You
my
give
lord.
the list.
I'll bring it on.
Your lordship,
Obligation.
I am for the respond number 1218, item number 2,
Mr.
MR Sharma.
M.R. Sharma for respondents.
128 in item number 2, WPC
What is
7
128?
WPC 7624 2015.
Who are the respondents 128?
They're private respondents.
Private.
Private respondents.
The applicants in the before the tribunal.
They are writ petitioners here in some of the writ petitions.
No, my lord.
They have been held to be
Legal, and they were
legally-
required to be paid the
legally
salaries.
paid.
That is what.
Mr. M.R. Sharma appears for 128. 128 in WPC 7624 of 2015. Yes.
I'm obliged, my lord.
Yes.
I have it.
Your affidavit has come.
Yeah, my.
Their salary,
Lordship,
not been paid their salary.
no, Lordship. That affidavit we have filed, those illegal and irregular teachers, Lordship. On last Friday, Monday perhaps, the
Uh,
matter came up,
And they filed a reply.
Lordship.
They filed a rejoinder.
They have filed rejoinder, Lordship. We verify.
Next week.
Lordship.
No, what verify? Why is it shown at Pathar?
Because Lordship, these petitioners were, their initial appointments were illegal and irregular. And subsequently, in terms of the cabinet decision, Lordship, they
They
appeared before the
they
scheme.
fall under which list?
Lordship,
They fall under which list?
they didn't, they fall under list 3.
List 3.
List 3 means, Lordship, some of them appeared, but they did not fulfill the criteria. So they were neither recommended as tutor nor recommended as teacher. Lordship, kindly come.
In this case, my lord, I want to point out that the list which they are referring, my lord, that sets of teachers are different, my lord, not this teacher. This teacher, and I have collected the copy of the water, my lord, in person to who is, my lord, that list was prepared, my lord.
Page number 66, Lordship,
Well,
affidavit.
Order was passed in WPC number 1048 of 2004, my lord, dated 2/3/2010, my lord. I have collected this order, my lord. in person to that order, my lord, they had.
You are relying on some orders passed by coordinate bench,
Coordinate bench.
where the matters have been remanded back to the authority
My
to
lord, my lord.
verify.
My lord.
So verification has already taken place.
My lord, that verification, my lord, that is why my lord, my grievance is that my lord, that verification which they have done carried out, my lord, that pertains to some other teacher, my lord, not the present petition, because
So where is the list? Where is
because
the
of
list of
that, my lord, kindly see, my lord.
Where is the list?
My lord, kindly see my the provincialization order, my lord. That provincialization was done in the year 2005, my lord. The order lordship will find at page minus 32nd, my lord.
Mr. Sharma, you are referring to the list somewhere
Lordship.
in your affidavit. Para 12, page 66.
Lordship. The answer independent humbly expressed that the names of the petitioners in the present writ petition, except petitioner number so and so, were found in the screening committee report under the Kasar district, but they have not fulfilled the criteria of receiving salaries after 2007 and onwards, and having joined JBT and DLED, etc., as laid down in the cabinet memorandum. Hence, they could not be accommodated as teacher or tutor. And in respect of these petitioners, no record were found in the screening committee. As such, cases could not be considered for accommodation as teacher or tutor. So this was the case. They appeared before the screening committee.
Your reply to para 12 is very vague. No specific details in your reply affidavit. Kindly see para 8 of your rejoinder affidavit.
Because, my lord, what I have stated, there, my lord, the service of these petitioners, my lord, were regularized as per the recommendation of the cabinet memorandum, sorry, cabinet meeting dated 24/5/2005. Subsequently, their service were regularized on 20th of August 2005. And that regularization order, my lord, on the strength of which the present petitioners were working, my lord.
So therefore, you have to challenge that order. That list which says that, you see, the statement which is made that some of the petitioners did not fulfill the criteria, and in respect of the others, there are no records found.
Right.
So
My
this
lord,
is the finding you have to
now,
challenge.
yes, I am appreciating that, my lord. What I am wanting to say, my lord, that inquiry, my lord, they are referring, my lord. I don't know, my lord. They are saying that the inquiry was conducted in terms of the order dated 10 to 2000. Sorry, my lord. Yes. 2/3/2010 passed in the WBC number 1048. Kindly see the cabinet memorandum they have annexed, my lord. Page 74, my lord. They are affidavit, my lord.
Yes.
My lord, here, my lord. Introduction and background. As second paragraph, in terms of the honorable court's final order dated 2/3/2010 passed in WBC number 1048 of 2004, the Education Department placed the matter of regulation of irregular teacher before the cabinet in meeting dated 26/2/2011. This cabinet meeting, well, there is far later than our cabinet meeting, because our cabinet meeting was held in the year 2005 itself. Well. Now, while they are referring or, my lord, including our name with that sets of teacher, my lord.
But the petitioners appeared in the screening committee, lordship. Records.
Then the screening committee, my lord, they have appeared, my lord. Kindly see, my lord, there is some orders, my lord, in this present petition, my lord. I cannot remember that order, my lord. Order dated, my lord. In pursuant to this order, my lord, some inquiry was, CID inquiry was conducted, my lord, and the petitioners had appeared, my lord.
Your prayer is for area salary.
My lord, not regularization, my lord.
But
I have already regularized, my lord, for
no,
further
very well, very
regularization.
well. But their affidavit says that these information are not available. And your the writ petitioners.
That is why, my lord, what I'm praying, my lord. Let them decide, my lord. That's why, my lord, the other two similar petitions, my lord, without disclosed of, my lord. I'm not on specific, my lord. If they are fine, they are eligible, my lord, they can consider, or if they are not eligible, they can reject it, my lord.
They have already stated in para 12.
Yep. No, my
You have
lord.
not responded there.
They are, my lord, para 12, they have stated and they have annexed the list, my lord. That list, I am not satisfied with that. That list, my lord, which they have prepared, my lord. The reference was made to the cabinet meeting dated in the year 2011, my lord. And I am only for area salary, and that cabinet meeting was for regularization or accommodation. Our services are already regularized, my lord. And we have served the department. And we are for salary, my lord.
And then why do you want the matter to be remanded to the authority to verify and
If
accept?
lordship, that is why, my lord, if lordship is my lord, considered, that is why, my lord. Since other similar to the petitions have been already, my lord, disposed of, my lord. In fact, my
Other
lord,
petitions
in fact,
have
my
been
lord,
disposed of, but then you have approached this court for a decision.
my
What
lord.
is the point in coming to court if the court has to remand back to the authority
my
for a
lord.
decision?
No, my lord, let them examine, that is why, my lord. Only to examine the earlier, since they are,
You have filed a writ petition making a claim.
yes, yes.
Now you want to go back to the authorities for them to verify.
Yes, no, no.
You can
what-
withdraw and
no,
go.
Not, I am not on that. Just, I am saying that since the other two petitions has been disposed of, my lord, and in Mansingh case also, my lord, the court, Supreme Court has held that, my lord. Once they have accepted the service, my lord.
The other two writ petitions are disposed of, but with all respect, these orders are not binding because there is no ratio.
No, yes, yes, not my, definitely not my.
Had they made a
I'm not
decision,
saying that binding.
that would have been binding.
Yes, yes.
Otherwise, what is the binding effect? It is merely remanding to the department to redecide.
Yes, outcome will be nothing.
Then you are before the court for a decision.
Yes, yes, my lord. In fact, my lord, they had, my lord, in their affidavit, they are also said that some of the, except some of petitioners, my lord, other petitioners have been serving, my lord. At least the department should pay the salary against those teachers, my lord, whose records are available with the department, my lord.
No,
If you are serving, the records are available in the school.
Yes, my lord.
It will be available in the school.
Yes, yes.
So where are the records? You bring it.
They had verified, my lord. They had the inquiry report, can you see it? They had their affidavit, my lord. They had stated in their affidavit, my lord.
Not recommended and working loss.
Were found on the instant committee report under capacity, but they have not fulfilled the criteria of receiving the salaries. They are never paid the salary. That is why they are before the court, my lord. How this can fulfill the salary, this criteria of receiving salary up to 2007, my lord.
Because their initial appointment itself was illegal, Lord, sir.
My lord, in
See,
fact,
it
my
is-
lord, that Monohan committee.
Mr. Counsel, please
My lord.
listen.
My lord.
You were initially appointed,
My lord.
then terminated,
Terminated.
then the court passes an order,
My
take
lord.
them back, you are
Reinstatement.
taken in
Yes,
back. Then there is a process of inquiry.
Yes, yes, my lord.
Right?
Yes.
Now, thereafter the cabinet takes a
Cabinet
decision.
meeting, yes.
Hmm.
And
And inquiry is made where there are classifications
yes, yes.
made.
Yes.
You appear before the inquiry committee, and there is a finding that as far as some of the petitioners are concerned, there are no records. No records. And again,
In respect of some
in
petitioners,
respect of some, and in respect of some, you don't fulfill that criteria.
they have put the criteria of receiving salary up to 2007.
Right.
My lord, that criteria how I can feel, my lord, because they have never paid my salary. In the only Kasar district, my lord. In other district, my lord, the services of the teachers, my lord, who were regularized under in person to the Monon committee report, they are still receiving their salary and other district.
The finding of the committee, is it in the terms of an order?
Lordship, in terms of that, 2004,
The committee conducted an inquiry,
Lordship,
classified them into different lists.
in terms of the cabinet memorandum, Lordship.
Very well.
Lordship.
Now, where does one get the minutes or order of the committee? There has to be an order of the committee.
Lordship, Lordship.
Where is that order?
But order is not there, Lordship. So if your Lordship directs, we have to produce.
No, but are the petitioners not entitled to have a copy to find out how their inquiry was conducted, what findings was there? If they agree, they can come before the court.
Let me have the instruction. Perhaps the petitioner has been intimated about their status, Lordship. Because they, in terms of the advertisement, they appeared before the screening committee. They produced their documents, credentials.
Right, but the committee has to pass an order.
Lordship.
That either there's
There is a list, there is an order, the minutes and the list.
these petitioners are required or
Lordship.
are genuinely working or required
Lordship.
to receive a salary, or
Lordship.
they're not required to receive a salary.
Those lists were prepared, Lordship. 3 lists were prepared. List one, those who received salary up to
So
2007.
where are those lists?
That list is not enclosed here. Lordship, we will produce personal. And those who,
Yes, Mr. Muzumdar.
My lord, if lordship has a look at the order dated 8/6/2022 of this honorable court.
Hmm.
A CID inquiry was ordered by this honorable court. That report, my lord, has not come perhaps on record because lordship will kindly have
8/6.
page. Yes, madam. Para 9 onwards, madam. A reading of the external portion of the communication dated 6/6/22 shows that the finance department, as per so and so, had issued a fax message to the Deputy Commissioner Kasa with information copied to Treasury Officer that it had come to notice that the finance department had fake appointment of teachers in Kasa district made on the strength of cabinet decision of 24/2005 with reference to a recommendation of the Manohan Commission, and accordingly, the Treasury Officer was instructed not to entertain any bill for payment of salary. In other words, it is the stand of the finance department that fake names are being included in the list of teachers who ought to have been regularized in the legitimate manner as per the cabinet decision of 24/2/05. As it is an allegation of fraud by the some authorities and persons bringing fake names to be included in the list of teachers who are regularized pursuant to the cabinet decision, we are of the view that the matter requires a thorough investigation by the appropriate authority in the government of Assam. Then lordship will find, for this purpose, we have requested Mr. Dinath so-and-so, para 12. Accordingly, we accept the suggestion of the learned senior government advocate and request the state CID through its SP to undertake the investigation as indicated above. The investigation shall include all the relevant officials of the education department who held their respective posts at the relevant point of time, as well as the person whose names were included in the list of 193 to be regularized pursuant to the cabinet decision, and therefore segregate the genuine persons from the fake entries. Upon completing the exercise, the investigation be brought to its logical end, meaning thereby that whosoever is found to have been committed the fraud be criminally proceeded for as law. If any persons who are required to be subjected by the investigation do not cooperate, the CID may take appropriate action as may be available under law. Preliminary report be submitted after 4 weeks. Now, my lord, 2 orders thereafter I have found. The next 2 orders, my lord, this report had not come on record. Even, my lord, on one of the orders on 26/6/2023, my lord, what had happened is this aspect of the matter was not pointed out to the honorable court, and therefore the honorable court again proceeded to find out to adjudicate upon the matter. Because on 26/6/2023, this order was not brought to the notice of the honorable court. Now, my lord, the cause list doesn't reflect the name of the government advocate.
No,
If
no.
perhaps
There is a direction
to the CID,
to conduct an inquiry.
my lord,
Assuming the CID proceeds or has proceeded, there
Right.
is some inquiry, some charge sheet leads that.
Right.
The fact remains that if these are illegal and fake, there has to be a decision taken by the authority
by the authorities, correct.
to recall or cancel these orders. And consequences of CID investigation, charge
Everything.
sheet will follow. That's a different issue. The issue before the court is their claim for area salary on the ground that they were regularized, have been working, then terminated. Initially, they were appointed, terminated, reinstated by orders of the court, then they have been working, but their salary has not been paid.
Number, if their initial entry to the service is found to be fake, if we go by Nazira Begum, Desker and others, my lord, Lordship will also find an order. If I'm not wrong, my
No,
lord,
no.
it was an old order.
No, Mr. Mazumdar. There is an order of the court pursuant to which they were reinstated
Yes, ma'am.
because they were terminated without notice.
Notice.
Right. So therefore, once they are reinstated, it is pursuant to the petitioners being reinstated that subsequently these committees have been constituted to make an inquiry to find out. Now, where is that inquiry report which says what is their status?
That would be the Manongal committee which he can bring in, my lord. Otherwise, since this honorable court at one point of time had taken a view that it would require an inquiry by the CID also, perhaps that report would be very
CID
necessary, my lord.
inquiry is on a different, that's on a criminal proceeding.
Hmm.
It is not only with regard to the petitioners, I'm sure it will involve some officers retired or present of the department.
True, my lord.
But is the court required to await or is helpless to pass any orders unless the CID investigations are complete? We are limiting our inquiry only to the claims of the writ petitioners, that whether they are entitled or not entitled to their area salary. That's all. Now, in the affidavit which was filed, para 12 makes it very categorical that some of the petitioners did not fulfill the criteria, they appeared. Some petitioners, although appeared, no records were found.
No.
Now, this has to be on the basis of some report, minutes. That is not before the court.
That report might not have to be, that had to come before this committee report, yes.
And whether these copies are served on the affected parties or not, how will they know? This person is before the court asking for area salary, and the department tells him by way of an affidavit that your records are not there. Where does he go?
How the manner in which that entire inquiry was conducted was we had given paper publications. People had put in their own papers. Had
You're
appeared
not
before the
getting the
committee.
point, Mr. Whatever order you have passed,
In that report.
there has to be an order. There has to be a finding culminating into an order or a minutes.
Yes.
They're entitled to see a copy of that if it is against them. Are they not?
That has to come. That is.
It is, in spite of affidavits being filed, instructions being placed, that copy is not here. It is perhaps not uploaded in your website.
That is not uploaded in the website. The Hindu Mohan Talukdar committee, the entire report is not there in the. So at one point of time, the entire.
No, we are referring to the report subsequently.
The expert committee.
Where the three lists are there. You go through the state's affidavit at para 12.
Yes, I have that. I have that.
This statement at para 12 has to be on the basis of the report. Have you seen that para 12? Please come to page 66 or internal page. I don't know. There's no internal page here. Para 12 of the state's affidavit filed on behalf of respondent 1.
The list. Page 71. 71 is on it. When neither salary nor deputy deputy charge. But I don't think I'm exit. Abdul Halim Laskar तो salary कोई नहीं लगा. No salary at all. No. They will follow the total list three. No salaries.
It is their claim. They are before the court since
12.
2012. And their prayer in the writ petition
Page 18.
His payment of area salary will effect from 2008-2005. So from 2008-2005, they have not received a salary. So obviously they will not fulfill the criteria.
They will not. Because their entry into service is in the basis of that regular, that cabinet memorandum of 2005.
Correct.
And the very allegation is that based on that 2005 cabinet memorandum,
Illegal
fake
persons-
entries
fake
were
entries
made,
were made.
and therefore they never received their salaries.
Right. So therefore, if otherwise their claims are correct, they were not fake entries,
Then they will be entitled.
but they will
If they
still
have
not,
worked.
they'll still not fulfill that 2007 criteria.
But, the criteria was if a salary for even a day had been, they had got the salary and they were trained, then they would be in the accommodated list as a
Correct.
teacher.
But your criteria said salary till May 2007 or something.
Yes.
So they have not received from
And
2005.
they have not received any salary from the date of.
But if they satisfy the other criteria, that they have the training, they were attending classes, then their cases will have to be considered.
Then the area salary part would come in, not
Will have to
the,
be
not the
considered.
accommodation part.
You cannot non-suit them on the ground that they do not satisfy the first criteria of receiving salary till May 2007. So therefore, the report is necessary.
Yes,
Inquiry report.
that report he has to bring on. That report he has to bring on record. Right? I was just pointing out that that CID part because it was not brought to the court.
You also make an inquiry and intimate the court and tell us. Because these orders passed by the coordinate benches are only for verification.
Yes.
On what basis will the verifications be made?
But if it comes out that their names were entered, they had fraudulently entered into that list in the cabinet memorandum,
Mr. Counsel.
then even if they have
No,
worked,
no,
my
no,
lord, they will
Mr.
not be
Counsel.
entitled.
That inquiry which is being made by the committee has given a criteria,
Yes.
right? So if that criteria is not fulfilled, either of the criteria is not fulfilled, they reject it, which is the case here. According to the department, they have not fulfilled, but which criteria they have not fulfilled have not been specified. And insofar as some petitioners are concerned, there are no records at all. But there has to be a finding that why these records are not available. Was it not furnished by the school? Was it not called for from the school? Are they fake entries? What kind of inquiry was conducted?
But that is regarding
And
the
assuming this inquiry is not sufficient, what further inquiry can the department conduct in terms of the orders of the coordinate bench? What kind of inquiry is contemplated?
But so far as the screening committee is concerned, my lord, I'm not on the result or report. My lord. That what has fallen from lordship is correct. Now, my lord, what if the CID inquiry finds that they were fraudulent entries at the very basis? Then Nazira Begum Law School would come in to deny them salaries, even the area salaries, because a fraudulent entry will never entitle to salary.
But what is
That
the
is what I was
finding?
trying to
What is the
express.
finding of that? Where is the finding of the CID?
My lord,
authority?
that is the
And
report, my lord, that has
Merely
also to come.
because the CID has arrived at a finding
Yes.
is not sufficient. It has to be, charge sheet will have to be filed, the proceedings will have to go on. Meanwhile, what happens? After 20 years, you come to realize that yes, they are not fraudulent entry. Who will accept the responsibility of paying all the salary? Maybe with interest.
Well, when they did not receive their salaries from 2005 and they did not approach this court till 2012.
Don't put the burden on the council. They are
No, not on the council,
they're
my lord. I'm on the,
citizens. I mean,
petitioners.
on the petitioner.
Someone
They're
does not get a
citizens.
salary from 2005.
They're citizens. Their claim is that we have got a job, we are working, we need to be paid a salary. Salary not paid. Where do they go? Department is conducting inquiries after inquiries. No specific finding where the records have gone, who is responsible for employing them, what kind of records. We'd also like to know that is the department aware that there is a CID investigation going on? Must be, because this is an order of the court.
They must be.
Now, if they come to a finding, yes, they fall under list 3, there are no records. Does it not indicate that perhaps this list 3 people require investigation by the CID? Why no records are available? Where have the records gone?
The committee, my lord, will have the expert committee report, my lord, that will show what records they had produced. and
Which
the
is what
CID
is
will-
surprising that it is not here in spite of so many pleadings being filed. We do not know what is there, what is the finding in the expert committee report. How the expert committee has gone in verification of the records.
The process followed was that there was paper advertisement, then they had gone to the district level, then they had gone to divisional level, then they went up to the state level, and then the expert committee took a decision.
So quite right, but that report has to be there. for
That
us to
report had to.
The learned counsels appearing for the department,
Details
Mr.
would be
R.
very
Mazumdar and Mr. P. N. Sharma, are permitted an opportunity to place the report or the minutes of the expert committee constituted for verification of the records pursuant to which cabinet order?
Expert committee can look into. That was, 2010. This was, in terms of this expert committee is pursuant to order date 2/3/2010 passed in WPC 1048 of 2004. Lordship will find it page 74. The second paragraph.
In terms of the order dated 2/3/2010 passed in WPC 1048 of 2004, as well as the cabinet, as well as the decision of the state cabinet in its meeting held on 26/2/2011. Stop. The same be placed before the court on the next date. Mr. S. Hawk, appears for the petitioner, Mr. Arbor for the finance department. Place it within 2 weeks.
3 weeks, Lordship.
3 weeks. Then we put it on 5th of March.
Lordship.
5th of March.
Okay.
Yes, Mr. Goswami.
Lordship. This is regarding selection and appointment of the post of revenue serious fraud in Nalbari, Lordship, in the office of the deputy commissioner.
Yes.
Selection is mainly on the basis of merit only. Lordship will find the advertisement at page 20 also. Advertisement at page 16.
Yes.
Advertisement is that Lordship, the dated 5/7/2019, and qualification has been prescribed. Candidates must have at least 15 years of service in the deputy commissioner establishment, Assam, and experience in different branch in general and revenue branch in particular. This is the qualification required as per rule also. And they should submit the application with proportional to the deputy commissioner, Nalbari, Assam, for selection. Selection will be made by the General Administrative Department as per Assam Ministerial District Establishment Service Rule 1967 and Assam Ministerial Service Establishment Amendment Rule 1999. Lordship will find that hereafter selection committee has been constituted and page 18, Lordship. Meeting of the selection committee for vacant post of administrative officer in the amalgamated establishment of deputy commissioner, North Sirang. Though Sirang has been stored, Lordship, for Nalbari also, it has been scheduled on 2/1/2020. Page 18, Lordship.
Yes.
Hereafter, Lordship, the page 20 is a letter dated 1st of July 1999.
Yes, please.
That is, Lordship, the procedure for selection. Lordship will find this is a circular. It is necessary for us to emphasize the clear terms that assessment of the comparative and merit and ability of every individual eligible candidate for selection and appointment to the post of revenue solicitor or head assistant or amalgamated establishment of deputy commissioner in any district in the state of Assam by selection of board consisting of deputy commissioner of the district, all subdivisional officers under him, district, and final selection by the concerned commissioner of the division strictly on merit for appointment to the post of revenue solicitor or head assistant in amalgamated establishment of deputy commissioner of the district under subdivision shall be on the basis of assessment of annual confidential report of every eligible candidate and other relevant service record, not any other basis such as interview or viva voice. So there is no viva voice or interview, only basis of ACR. Circular main copy is at page 22, Lordship. I have read the type copy. Lordship, thereafter, the government has selected the respondent and appointed by order dated 27 January 2020, subject to revision without any notice, assigning any region thereof. On recommendation of selection board, selection candidate to the post of revenue solicitor Umesh Chandra Das, senior assistant of Deputy Commissioner Nalbari in the post of revenue solicitor in the amalgamated establishment of Deputy Commissioner Nalbari in the scale of command per month. It's the appointment order of respondent number 7 that is under silent as well as the selection. Now I will take your Lordship to the, I have taken under the RTA information, the selection and assessment of merit and the ACR of the all the person who has page 26 is the RTA information. Lordship. Now I'll take your Lordship to the Lordship, the assessment part, page 27, not the assessment part, the regarding ACR. Because ACR is the criteria for assessment of merit, Lordship.
Page number?
Page 27.
Yeah.
Lordship will find the respondent number 7 is the Umesh Chandra Das, who has been selected. And next one is Bhubaneswar Sharma, Lordship. Now I will take it to 5 years ACR from 2014 up to 2019, Lordship.
Yes.
Lordship will find first three Umesh Das. Lordship will find 2014-15, his ACR has been shown as good. That is period 1414 to 31-15. My case, Lordship, here is a 1414 to 11414, very good. 12-11-2014 to 3-13, very good. He is good, Lordship. I am very good. 15-16, 1420, 15 to 31, very good. Thereafter, Lordship, good. In my case, Lordship will find very good, very good. Lordship, good. Next, Lordship, 2016-17. His period for 1416 to 14716, good. Thereafter, 39-2016, very good. Thereafter, 110-16 to 31-317, very good. In my case, Lordship, there is nothing on the column. Thereafter, Lordship, 18-19, first period, good. Next period, very good. My position is very good, Lordship. And regarding this period, Lordship, there is a special report submitted by the authority where my recommendation has been kept that I am very good, Lordship. This period, no,
17 to 19.
17-19, very good. Special report has been submitted.
Okay. There were 4 persons.
Lordship.
Then?
Lordship, again, see page 29, Lordship.
What is this?
This is also a statement showing details. Another information I have received where this period which has not been mentioned is very good. 2009, that is an RTI information. Bhubaneswar Sharma, second column. This period was 2017 to 19, very good, Lordship.
Yeah.
So my submission will be, Lordship, the assessment should be made on the basis of merit. And there is no interview, there is no viva voice, only on the basis of ACR and service particulars, petitioner have to be selected and appointed. And I have tried to collect how the grading should be given. Regarding, Lordship, what very good, how much, and in good, what will be the marks. I try to collect from the GAD authority that what is the procedure of selecting mark But I have collected, Lordship, the information how marks has been given in other department. Lordship, the other department for below average 0 point, for average 1 point, good 2 points, very good 3 points, outstanding 4 points. This is the assessment of merit. May I give? This is a DPC or other department. How Lordship the ACR has been calculated, marks has been calculated.
This is what? This is a
This is the DPC of other department. that is
other department.
Other department. But I could not collect from the GAD authorities.
But
Now-
there is no uniform circular.
There is a personal circular from the personal department. Personal department is the authority, they have a circular. But I could not collect this, Lordship. But I have collected this information from other DPC. That this is the procedure of assessment of merit. And merit has been assessed for 5 years. Lordship will find it in every person. Merit has been assessed on the basis of ACR.
Yes.
So my submission to be, Lordship, on the basis of ACR,
Yes.
merit should be assessed. Only they have taken a stand in the Lordship, private respondent has taken a stand that there is a provision for appeal under section 12, under rule 12 of the Assam District Establishment Ministerial Service Rule. That is why writ petition should not be entertained. Right of appeal. Right of appeal. Every member of a service shall have right to appeal from the order of the deputy commissioner, the commissioner, and from the order of the commissioner to the chief secretary.
Yes.
Here, Lordship, my reply will be, Lordship, kindly see my prayer. I have prayed. Lordship will find that as to why appointment of the private respondent to the post of revenue solicitor in the amalgamated establishment of deputy commissioner Albari dated demand issued by the secretary government of Assam General Administrative Department shall not be set aside and quashed. And recommendation of selection committee meeting held at Iman. So I have challenged not only this appointment, I have challenged the selection and recommendation of the selection committee. That is why, Lordship, though appeal is there is a provided an order against the deputy commissioner, but selection there is no provision for appeal. That will be my answer, Lordship. And Lordship will find the affidavit filed by the GAD. They have stated, Lordship, in para 17, page 41. Their specifics then,
Yes.
specifics then para 17. They have said, Lordship, there is no provision for calculating marks. How they will assess merit? My submission will be, Lordship, there should be some assessment of merit. And Lordship will go through the Lordship the recommendation how they have assessed the merit. Merit should be assessed as per circular on the basis of ACR. There is no interview, no viva voice. So there should be some criteria for assessment of merit. Other department has followed this procedure. How they have assessment of merit, Lordship will see the record. If there is a procedure, they have calculated the marks, I have no case. He is higher on merit. But my submission will be on the basis of ACR, my merit is higher. So I have challenged the selection and appointment of the private respondent. And one thing I have stated that I have worked in the revenue department more than him. That will be come into consideration when merit of two persons have become equal, preference will be given to me. But here I cannot see the merit, how they have assessed the merit. Preference will be given to the person who has worked in the revenue department. So I have worked more than him, the revenue department. But I could not collect the marks because it is on the DPC. And the personal department circular, I could not regarding assessment of merit. Lordship can see the merit, how they have calculated the merit. Because there is no FIBA voice, admittedly, Lordship, there is no intern. And
So according to you, there was no assessment or procedure for assessing merit,
no, there is a procedure, Lordship. There is, as per my knowledge, in
but they have
other-
not followed it.
Lordship, merit have to be assessed on the basis of performance and ACR. ACR grading had in my case. And they have said one period was there, not there in the ACR regarding my assessment and merit. There is a special report which Lordship has allowed me to inspect. There is a special report from the department regarding my ACR for the period where in the list there is no disclosure. A special report has specifically stated very good and beyond doubt. That I have, Lordship. I have collected from the GAD.
It must be available in the
It is fine.
records.
Lordship, it is available. It is very good, Lordship. I have, Lordship, I can also pass over. So that is my case, Lordship.
You are relying on some judgments.
Regarding, Lordship, the judgment I have relied on. Only one thing, Lordship, will kindly see. Alternative remedy, they have stated that there is a provision for appeal. And the Honorable Guwahati High Court, Honorable Justice B.K. Sharma has passed an order on 2004 to GLR page 406, para 20. Alternative remedy become infructuous when matter has been heard and decided, but here there is no alternative remedy.
You are relying on 2012 1 GLT.
2004 to GLR 406, para 20.
2004
to GLR, page 406, regarding alternative remedy. They have stated that there is a provision for appeal. Para 20. Lord.
Yes.
Otherwise, Lordship, my case is based on that I am superior on merit. So my case should have been considered.
Yes.
If Lordship, there is no assessment of merit, Lordship will set aside the selection. I told you. File is kept by the GAD, Lordship. Lordship can see the file regarding assessment of merit. And if Lordship, I found the ACR performance, my merit is good, I will get a selection. Otherwise, Lordship, if merit is not assessed, it will go, Lordship. That is my submission.
Okay.
And I subject to my giving reply to the other side.
Yes. Comment. Yes. According to you, merit has been assessed. But how have you assessed merit unless there is any marking system or?
Regarding the ACR grading, Lordship, that particular thing is done by the DC concerned because they are the main reporting authority. So the DC concerned basically grades them, and after grading them, this very good, everything is assessed. So that part, Lordship, the government advocate will be able to say. But after that, Lordship, after the 5 years, as per rules, 15 years first has to be seen. As per 8.1b, the Lordship comes to 8.1b. Of the Ministerial District Establishment Rules 1967. It's at page 198 of this book.
198.
Yes, Lord.
Yes. Yes.
In 198, this post is basically Lordship for revenue shareholder. Lordship, in 190, before I come to the main point, Lordship, if your Lordship comes to page 199 below, 199 below.
1 minute. Yes, 199.
9, Your Lordship. If Your Lordship sees below at Roman 5, Your Lordship. Below that, the rank and status of the post of administrative officer shall be equal to that of the revenue scheduler. So AO and RS are the same in terms of rank and status.
This is administrative officer.
No,
Yes,
revenue
this is revenue scheduler, but the rank and status is same. Your Lordship flips the page to the next thing. It's 2. There it's given the job description of AO and revenue scheduler shall be as follows. So for revenue, all revenue matters, Your Lordship, will be looked after by revenue scheduler. All revenue matters. 2 Roman 1. All revenue matters, the job descriptions are different. So for revenue matters, it will be looked after by the revenue scheduler.
Then what is the job of the administrative officer?
Administrative officer, Your Lordship, will look after the subjects like personnel branch, magistrate branch, and the planning and development branch.
Okay.
So usually people who have experience from revenue are generally pulled into the revenue scheduler post. And AO, Your Lordship, are these branches. People with more of administrative experience, Your Lordship.
Yes.
Thereafter, Lordship, now we can come to the main this thing, Lordship. We turn back the 8.1. If you flip, Lordship, again back, the post of administrative officer shall be filled up by selection from amongst persons who have served for at least 15 years in any this deputy commissioner's establishment and having working experience of different branches in general and in the establishment branch in particular. So, Lordship, and have these required qualifications they have to have, that is graduate degree and in any discipline from a recognized university. Now, Your Lordship, in this case, the petitioner, Your Lordship, has joined on 28/8/1990, and the respondent number 4 has joined on 4/4/1990. So both have completed their 15 years on 4/4/2005 and 28/8/2005. So technically, the respondent number 4 in this matter is senior to the petitioner over here, Lordship.
Yes.
Thereafter, Your Lordship, what has happened is, thereafter, Your Lordship, in terms of revenue, Your Lordship, now I would like to produce a record over here because the record will be crucial here. In the
No, you take us through the rules first.
Yes, Your Lordship. So, Your Lordship, the rules here, again, after 8.1b, the appointing authority, for the purpose of selection, there shall be a selection board, Your Lordship. And accordingly, this selection board, based on the 5 years grading.
Then number 3.
Yes, sir, 3. The appointing authority shall advertise the vacancies by itself or may instruct the deputy commissioner concerned to advertise the vacancies, inviting application from suitable persons eligible for appointment in the post of AO. In this case, Your Lordship, it's the RS, basically. Fulfilling the requirement of the post as per clause I. I again is 8I. So in this case, both have got 15 years. And in fact, the R4 is senior. And this being a RS post, then, Your Lordship, the appointing authority shall obtain the ACRs for the last 5 years and relevant service particulars of the eligible candidates for recruitment to the cadre of AO. In this case, Your Lordship, the RS again, and place the annual confidential reports along with relevant service particulars of the candidates before the selection board with the number of vacancies likely to occur during the year. The selection board shall examine the ACRs and service particulars. The selection board shall examine the ACRs and service particulars of the candidates, taking into consideration of the respective merit of the candidates, and prepare. Merit is the main criteria, and prepare a list of the names in order of preference for recruitment to the said post. The list shall be prepared shall be forwarded to the appointing authority by selection board. The list finally approved by the appointing authority shall be the select list for the purpose of appointment of AO. In this case, Your Lordship, RS. So accordingly, Your Lordship, the vacancy, the ACRs were sent by the district commissioner of that particular district, Your Lordship. That particular, if Your Lordship sees in the record, Your Lordship, will be crucial here, because there, Your Lordship, the actual this thing will come out. Who has worked in what kind of a role, Your Lordship. So in this case, Your Lordship, since the R4 on basis of the record has, Your Lordship, got revenue experience more, on that basis he was selected, Your Lordship. That's what we can gather, Your Lordship.
No, but your requirement is establishment branch in particular.
No, but Your Lordship, that is for in the rules, it's given for AO, but in
This is the post is for AO, isn't it?
no, RS, revenue solicitor. That's why, Your Lordship, I read you the page 199 first.
Let's go to the advertisement again.
Yes, Your Lordship. Advertisement is at page, what is it?
16.
16, Your Lordship.
Revenue Siras.
Definitely. So in 199, Your Lordship, already it's given rank and status. So these rules are only followed since the rank and status of both AO and RS is same. But this thing is, so Your Lordship, I would like to place the record, Your Lordship, for
1 minute. Let us take us to the rules properly.
yes, Lordship. Thereafter, Your Lordship, after that, Your Lordship, the list finally approved by the rule 8(4), the list finally approved by the appointing authority.
So
Shall be
come to clause 3 again.
Clause 3, Your Lordship. The appointing authority shall advertise the vacancies by itself or may instruct the deputy commissioner concerned to advertise the vacancies, inviting application from suitable persons eligible for appointment in the post of administrative officer. So in this case, Your Lordship, RS, because they both are same post. And then fulfilling the requirement of the post as per clause I. I is also 8I, wherein both the candidates have fulfilled the criteria. That is, both are 15 years and both have got graduate degree in any discipline having recognized university. Thereafter, Lordship, again, if you read the same thing, the appointing authority shall obtain the ACRs for the last 5 consecutive years. That is from the DC of that particular district, Lordship. And that DC basically grades
Gives the ACR ranking.
ACR
Yes.
grading.
Yes.
Based on the ACR grading, Your Lordship, and place the ACR along with the relevant service particulars of the candidates before the selection board. Here the selection board comes in. Your Lordship. Based on that particular grading only, they select the candidate with the number of vacancies likely to occur during the year.
Okay.
Thereafter, the selection board shall examine the ACRs and service particulars of the candidates, taking into the consideration of the respective merit of the candidates. So the main thing is merit.
Yes.
In terms of Lordship, of course, in terms of their ACRs also, and also in terms of the kind of role they have played. If it's an AO, an administrative person will be more eligible for that.
They were working in the post of?
They were supervisory. Supervisory, both are
UDA.
supervisory.
I'm working in supervisory.
Same.
It's in the rank of UDA.
Above the UDA.
Above
UDA.
So both are supervisory assistants and both have 15 years. Only thing that respond number 4.
According to the department, he's got more experience in revenue matters.
In revenue matters. That is why he was selected. Otherwise, if it was an AO post, I think, my lord, he would have been more eligible for the post.
All right.
And my lord, I would like the records might be
Very well, the records are there. Anything else?
Lordship, and
How do you say?
apart from that, Lordship,
Yes.
one more thing I just wanted to add was regarding the Rule 12. There was I mean, of course, he has come directly to the court, but there was an alternate remedy available
For an appeal.
for an appeal before the
Very
chief secretary. Before coming. So that is my stand, Lordship, for the
Very good. Now, how do you support your submissions that the selection was done as per merit? How is the merit to be assessed?
Lordship, the
In
merit,
the absence of any specific rules? or
Lordship,
circulars?
two things, Lordship. The one is the ACR. ACR grading, again, that ACR will have to come in. ACR which has been annexed by the petitioner, Lordship, at Lordship, page 27.
Huh?
There, Lordship, respond number 4 is Umesh Das.
Hmm.
So from 2014 to 2014, he has been marked as good. and thereafter Bhubaneswar Sharma has been marked as very good. 15-16, Your Lordship, Umesh Das has been marked as very good. Bhubaneswar Sharma also has been marked as very good. 16-17, Lordship, he has been marked as very good. Whereas Bhubaneswar Sharma here, the marking is not given here. For 2010-17 to 14-1 2019. Here, no remark is there. Your Lordship comes to page 27. 2010-17 to 14-1 2019.
Page 29 is the Lordship the giving copy. Page 29 is the Lordship RTI information copy. Very good.
Oh, it is there. It is there. Very good, Your Lordship. So both are very good. Thereafter, Your Lordship, again 17-18. Very good for Umesh Das, 1-4. Very good for Bhubaneswar Sharma. Thereafter, 19-20, special report. Both special reports, my lord. Both are very good.
What is this special report?
This, my lord, the government advocate will be able to say, my lord.
Huh?
He will be able to say, my lord, he,
Who's the government advocate?
because they are the grading consular.
Apparently, my selection is made by the GAD and assessment done by them because SCRs are sent by the Deputy Commissioner. On the basis of assessment, SCRs report, the selection committee, they have decided how much they will be obtained against good, very good, average like that. Deputy Commissioner only send by lot average good, very good like that. SCRs, and he has no other control over the selection. The selection is made by the GAD department.
No, we want to know what is the special report. Why special report is necessary? Any significance of special report? Because these gradings in the ACRs are not all are not on the basis of special report, except for one or two.
And any other, apart from that, any other special report?
No. You look into the chart enclosed to the writ petition. Come to page number 27.
27. Yes.
If you look into the second column from the right, you'll find special report.
Yes.
So why
special
special
report submit separately in the Annex 1? Special report is submit separately. That is special report is in the affidavit. I have not found, my lord.
That is on the basis of other service particular. Other
Oh,
service.
my lord, regarding their working, their experience regarding in different branches, that has been mentioned. That has been mentioned, my lord, in our affidavit.
Available in the ACR.
ACR, normal, our affidavit also can see. Deputy Commissioner.
Okay. Yes, man. Who is for the private respondent? Anything? Mr. Ali?
Hey, Ali.
Hello.
You are for the private respondent. Anything to submit? Alternative remedy. Alternative remedy.
I would like to add, my lord, one thing, my lord.
Ah.
In the page 27.
Yes.
Page 27, my lord. This was prepared by the Deputy Commissioner, my lord, on 31/12/2019. Page 28 is the signature, my lord. Now here, page 27, your lordship will find for the period 2015 and 16, bottom, my lord, for writ petitioner.
15 and 16.
15 and 16. It was made up to, my lord, 14/7/2016.
Yes.
1/4/2016 to
No.
14/7/2016.
16.
Thereafter, my lord, there is no ACR.
From
And
15.
next ACR was prepared, my lord, from 2010
So from-
2017.
So from 15/7 to 19/10.
Lordship.
From 15/7
Yes, my lord.
2016
15/7 2016 to 19/10 2017.
17. No
There is
ACR.
no ACR. And there is no remark also.
Page 28, Lordship.
Now,
Page 29. Page 29, everything is recorded.
29, my lord, is there is no signature of any officer, my lord.
That is in the file.
I don't know.
File number is there.
There is no signature. And it is dated, my lord, 29, page 29, my lord. It was dated 23/10,
That is 23/10/2019.
2019. And page 27, my lord, is dated, my lord, 31/12. Page 28, and bottom, my lord, date has been put, my lord.
31,
12.
12.
So here, my lord, there is a specific gap for, my lord, 15 months.
No, 31, 31, 12.
12. This is the, my lord, last one.
31, 12, 15. No, what is that?
19.
19. No, so what do you want to submit?
So, my lord, here, my lord, specifically, my lord, there is a gap for 15 months. There is no remark of ACR. There is no ACR.
No, but what do you say about page 29?
29, my lord, this is, my lord, prepared in the month of 12, month of October. So, after this, my lord, final list was prepared. Final comparison made, my lord, in the month of December. And page 29 is unsigned, my lord.
What does the government say here?
That is on the
Mr. Fukan? They come to page 27. Come to page number 27, bottom. For the year 2015-16, insofar as the writ petitioner is concerned, his ACRs are available to 14/7/2016. Up to 14/7/2016. Do you get it? Yes. Next ACRs begins at 2010/2017. So the private respondents council is raising an objection or a query that there is a gap from 15/7/2016 to 19/10/2017. Whereas petitioner has relied on page number 29, where he says that the gap has been covered. Now, what is the position in the records?
And page 29 is, my lord, unsigned document.
And it is unsigned. But if it is available in the records, it is.
Just check it up. That is available on record.
I have all the.
Yes. Regarding assessment of merit, what do you say?
Regarding assessment of merit, my lord, the
How is inter se merit to be?
my lord, in my all ACRs, my lord, there is a note, my lord, that he is a fit for promotion, my lord.
So that note is also there in case
So,
of
my lord,
petitioner.
so both are, my lord, eligible, my lord, under section 6, my lord. Under rule 6, he has completed 15 years. I have also completed 15 years. Now, my lord, the merit has been assessed, my lord, by the government, my lord, and found the respondent number 4, my lord, more, my lord, eligible than the writ petitioner.
That is what I am saying. On what basis?
And on the basis of report, my lord, available before the department, my lord. Ox or and seniority, everything has been calculated, my lord. Earlier, my lord, I have relied on judgment I have given to you, lordship, my lord, whether it is on the report file or not. 2014 1 SCC, my lord. 2014 1 SCC.
2014.
603. have given to law,
2014.
Commissioner of Income Tax, my lord,
That is alternative remedy.
lordship.
Yes.
And
No,
here the right of the petitioner, my lord, has been, my lord, his right, my lord, has been created by a statute, my lord, regarding promotion.
No, that is okay, but
And
what do you
lordship.
say about assessment of merit?
And his right has been created, my lord, under a specific statute, my lord. And under the statute, there is a specific provision of it.
What is your submission with regard to inter se merit?
Regarding merit, my lord, the petitioner is found, my lord, more suitable on the basis of service record available before the department. And he has served, my lord, more than the writ petitioner.
Okay.
I've taken out the gradation list.
Huh?
Gradation list.
Who has relied on this judgment, Romani Malakar, by the petitioner?
Lordship.
You have relied.
Lordship, because I have filed a case regarding Romani Malakar. In this case, Lordship, same selection process, equivalent post revenue officer and the administrative officer. This is a post of administrative officer, and this court has interfered and allowed the appeal, the petition. Same post.
On what ground?
On the ground of Lordship, the ACR.
Lordship, that case, Lordship, I had appeared in that matter. That case
15 years,
of
only 15 years experience
there
was not there, Lordship. The private respondent has no 15 years of experience. That is why his selection was set aside. His section set aside and allowed.
The crux was different, Lordship. There, Lordship, it was for administrative officer specifically. And there what had happened was the respondent number 4 actually did not have 15 years. Actually, he had eligibility as per merit because he had the experience and the thing, but he was disqualified. And that particular order was set aside because of the fact that he did not complete 15 years. So the court in that case held that, first of all, to come to into the zone of consideration, first one has to fulfill the criteria of coming into 15 years. In that case, it was separate enough. This case is totally different. Here, both the candidates have got 15 years. And here, RS post has to be seen.
This was placed only on the ground that appeal should be preferred, not on this.
Okay. What about merit? How to decide on merit? What is the criteria? When there are no express principles or rules laid down?
Under Rule 6, my lord,
Rule 6 does not lay down.
only 15 years, my lord.
No, there is no dispute on 15
No.
years. The dispute is on
How
that
they
the
calculate.
merit has not been assessed. Now the rules are silent. There is no circular. The minutes perhaps will go to the records. Have the minutes laid down how the merit is to be assessed? Minutes of the meeting?
Lordship, in the minutes, I have got it over here. Minutes, what they have done, they have not given the reason thing as to how they have selected. That is the issue. Last time also I had shown the record. Lordship had seen that. Then Lordship had asked me to showcase basically how do you assess the revenue who has got more service in revenue or administrative thing. Here, Lordship, on the last occasion, I have marked the thing where both their service records have been where they have worked from the internet.
Okay.
So I will showcase that. But Lordship, the government council also will have to, because the
Regarding the annex page 27, this statement, but the original record it does not tell you with that.
Huh?
Statement showing details of the candidate who applied for the post of revenue assessor. These are records, original records, seal and signature, madam. The copies annex CIT does not tell you it like that.
Which copies?
These
the
page
gradation
27.
list, Lordship, where the grading is done.
Where is that?
Statement showing the comparative statement.
Here, the qualifications and all is given here in the main page 27.
No, you are referring to which page? 27.
Yes, page 27. The gradation list, the grade.
Yes.
Party information দিতে ভালে very good আছে
Itu good.
As per record, everything is very good.
Lordship, this thing doesn't tally. It should have been same. If it's an RTI thing, it should have been same as the main record. The record is over here.
No, what doesn't tally?
The Lordship,
You
tables,
point out with
tables.
with reference to page 27.
Page 27, Your Lordship, first is Umesh Das. Here, your ship, it should have been gradation list one, gradation list serial number one. Then caste also should be given here. There's no caste here. Then
Like,
next,
these are
thing is
irrelevant.
date of
Date
joining,
of joining is there.
junior assistant. Here, date of joining, of course, is there.
Hmm.
Then date of superannuation is there. Then here, of course, it's there. But here again is different. Date of superannuation of Umesh Das is 31/3/27.
Hmm.
Here it's given as 12/10, which he has annexed as 12/10/20. 2000.
31/3/2027.
27.
31/3/27.
10.
Eight with annex করা কথা।
Date of joining is given and the date of superannuation is not given here. Then thereafter, your chip, date of, there are different heads given in the page 27 and the record is different.
Record is different. Everything is okay.
No, I mean,
You tell you
The
go
first
through and
page of-
We'll have to check it, my lord,
Check it,
through the record.
check
I
it,
have to
check
go through it, my lord.
check it.
Yes,
Check it up.
my lord. Let it be another day, my lord. I will sit with the. No, I will see. That was it.
You check it and tell us.
আগে ডিসেম্বলি কইছে তো
No, it's not shown, but
আগে ডিসেম্বলি কো বলো আগে কো করে না দ্যাট টু
সব না একটু একটু এখন আপনি দেখাইছে এখন একে
সাম মিলাইছো
মিলাই সব সেম বস্তু
ঠিক আছে
উল্টা পুল্টা হয়ে রই
সাইলো
না একটু ট্রাই একটু শোনা না তোমালোকৰ আছে ইনফরমেশন এই পেজটো
মই মিলাইছাম মানে বস্তু
এইটো সব না এটা
You
Well-
check it and tell us. We'll keep it on 20/20 February.
20 my lord.
We'll try to dispose of on that day.
Yes, on that date I will submit it because I'm going through the record, my lord.
Yes. But make the records available.
well, record is available. It should be, but this is made by this gradation list made by the deputy commissioner itself. That's why the seal and signature is here.
only
He's representing the
remains
DCC.
regarding comparison what I have given in the RTA information receipt and
I don't think we found any discrepancy last time. You know, if they want to satisfy, let them satisfy.
And
Matter be listed on 20 February.
only one thing may I submit. They have submitting only one thing that senior he is senior to me. When merit is to be considered, seniority has no role to play.
No,
That is
you-
it.
We have recorded your argument.
It is another aspect, it is another aspect. It is not a sole criteria.
my lord,
Yes.
one more thing on the last occasion, Rakshit had asked me to point that out. The service record of both the petitioner and the respondent, that I have also marked it. And I'll show it in the next page.
All right.
20. huh?
Apply this.
Which tarikh hai? Nafi, ये- what do you call it?
My lord may kindly pass over for the timing, your lordship. R. Mazumdar is taking care of the matter, your lordship. He is on live.
There are other councils. Why do you have to
They have already filed their affidavit, Lordship, and we have filed a rejoinder.
rejoinder? What is the issue about?
Lordship, the issue here is, Lordship, our services were provincialized after 3 rounds of verifications, both at the district and state level, after working in the fencer state. And provincialization was done on 4/2/2021. Then thereafter, Lordship, the director, all of a sudden, Lordship, in 2022, Lordship, 34/2022, Lordship, has stopped our salary, saying that, Lordship, our subject concurrence was received after 1/1/2006.
Your
Our subject, particular subject concurrence was received after 1/1/2006. Now, our stand
subject
here
concurrence is to be received from whom?
from the council law,
Higher secondary.
high secondary council. Lordship, our contention is that, Lordship, that process was done prior to 1/1/2006. But because of, Lordship, the communications and other things, Lordship, the
Where is
subject
that?
concurrence was received after 1/1/2006.
Where is that order of the,
Otherwise, Lordship, the school.
where is
was-
the order of the director?
Yes, Lord.
At page 19, Lord.
19.
19, Lord. Page 19 is the imping order, Lordship. And the
Okay.
provincialization order, your Lordship will find at page 17. Our provincialization order. It is
Now, what is the stand of the department?
their stand of India affidavit. They have stated that Lordship, they have now sent the government. They have sent this matter to the government for inspection. Now, Lordship, without taking approval from the finance department, we are now regular employee of the.
You are not getting your salaries.
From Lordship 34 2022, from April.
No salary.
No salary, Lordship. But still we are working. And no so cause, only in respect of two petitioners in Pawan Rahan and one Lordship 50 Mindas, they have said that they have issued notice, but in this case, Lordship, there is no notice. Abruptly stop our salary, Lordship, for the last almost 2 years, Lordship. From April, in respect of some petitioners, it is April, but in July, May. And in respect of some other petitioners, it is May and July, May and April.
And what is the stand of the government? Nothing. You are not aware. Let Mr. Mozumdar come.
There are 4 of our affidavit.
Very well. Call Mr. Mozumdar. Will take up at 2 p.m.
Yes, Your Lordship.
At 2 p.m.
Very clear, Your Lordship. My lord, in this case, the writ petitioner filed a rejoinder today, Lordship. So I need some time, Lordship, to go through that because they have admitted our.
The entitlement is admitted, my lord. but-
Entitlement admitted, but about the shell, let me take instruction within 2-4 days, Lordship. And if need, I will file an additional affidavit on that also. Entitlement there.
Who's the first wife?
I'm.
You're the
She-
first wife.
Yes.
And who's the respondent?
Respondent number 8 is the second wife, Lordship.
You're not entitled.
Lordship, I am entitled.
How? How are you entitled?
I'll show Lordship. And apart from that, Lordship, whether, because since he has filed a rejoinder, Lordship.
No, that's different issue. We want to know how you are entitled. Well, pension to some? Pension?
They have admitted, Lordship, in their.
If they admitted,
They have
under the
admitted.
provisions, are you
I'm
entitled? Both are surviving.
Lordship, both are surviving.
So she's the elder one.
Lord, or as per the full bench judgment, Lordship, she is to receive the amount, Lordship. And
The amount is payable to first wife, my lord.
payable to first wife. I am not disputing that.
Then?
But she should have to pay my share, Lordship.
No. Where on the full bench is that direction?
I am coming, Lordship.
Is the judgment enclosed?
Lordship, I am coming.
Is it enclosed?
Not yet.
No, my lord. I have a copy.
I am supplying the copy of the judgment, Lordship. There are 2 judgments, division bench, 1 judgment is there, and apart from that.
No, full bench judgment.
Lordship, I am coming.
Yunufa Begum, is it?
Yes, Lord.
Lordship, I have a copy of that, Lordship. And then
Where it's been stated? Para 19,
Lordship, I am coming from paragraph 15, Lordship.
15. All right.
As may I read, Lordship? As reading Rule 143 goes to show that for the purpose of family pension, a family would comprise of the relatives of the officer, which also includes the wife in case of a male officer. If the second or further wives of a male officer are acceptable and valid under the personal law governing the parties, we see no reason as to why such second or further wives would not be construed to be a wife of the female officer. Then Lordship, paragraph 16, next para. If the validity of the acceptability to the marriage of a second wife, they have admitted, Lordship, in the writ petition. Further wives, where the parties are governed by Mohammedan law, would be determined by the personal laws of the parties. And the personal laws provide for the validity and acceptability of such marriage. The second wife or the further wives, where parties are governed by the Mohammedan law, would have to be construed to be also the family members of the deceased employee, and therefore, under Rule 43(1) of the pension rules of 1916, be entitled to the benefits of a family pension, Lordship. Then, Lordship, paragraph 20, Lordship. As contrary to the provisions of 143 pension rule, 1 would have to be read to mean the family pension would be payable to the eldest of the surviving widows of the, in the event there are 2 or more wives, and thereafter, on her death, it would be payable to the next surviving widows, if any, so and so. In these circumstances, the concept of validity on acceptance of the second marriage, where the parties are governed by the Mohammedan law and the consequential entitled to the benefits of a family pension, the concept of whom the family pension would be payable under the pension rule are held to be two separate and unrelated concepts, and the implications of the concept of a validity and acceptability of a second marriage or further marriage where the parties are governed by the Mohammedan law would have no bearing on the concept of whom the family pension is payable under so and so rule. It is held that irrespective of the validity and acceptability of the second marriage, further marriage where
Your
the parties,
remedy lies before appropriate forum, para 23.
Lordship.
You go and file.
Yes, para 23. So this is a question of facts.
What further adjudication is necessary after full bench?
And
Lordship, no, I am coming on that. Lordship, they have admitted my position.
Right.
And subsequently, as per new, that is August notification,
The
17th
petition
August.
the
is,
notification is before the
petition is
final.
not filed by you, it is filed by them.
Lordship. No, I am only that, Lordship, because I filed objection. I have an annexure in the writ petition, Lordship.
The petitioners, the department cannot withhold the pension.
Lordship.
No, my lord.
Lordship.
Cannot withhold the pension.
No,
If
no,
she is
I am not
first wife.
withdrawing. I am not withdrawing. She should have to receive it.
Right.
But she should, as per rule, if the family pension, Lordship, 17 August 22 notification, note number 2 clause, the following new clauses shall be inserted, namely, if the family pension recipient does not divide the amount among the other beneficiaries in equal shares, and on receipt of such complaint from the eligible family members, the competent authority shall issue orders apportioning the family pension among the other eligible family members. Only on that point, Lordship.
No, no,
This
that
is
will have to be
reflected in
read
para
with the
23.
rules.
Lordship.
So long the first wife is alive,
Lordship.
family pension is to be paid as per the rules.
Lordship.
There is no claim for the second wife. Second wife's claim is only with reference to para 23.
Lordship.
That you go and claim your maintenance if she is not giving you.
Lordship, because they are living separately, Lordship.
Maybe.
So,
There is no direction that you have to, there is no precondition that you
no,
have to.
I am not on that,
together.
Lordship. My respect to submission is that, Lordship,
Hmm.
that is the family pension as per rule, or they have admitted in their additional to this affidavit, rejoinder affidavit, Lordship, he has admitted, and she is also
Admission, my
ready
lord,
to.
admission is limited to the fact that since she is a family member,
Wait,
we will maintain her.
What is
We
your
will provide
demands now?
maintenance.
What do you want?
Lordship, my respect to submission, Lordship, she is not paying anything, Lordship.
So you go and claim, we can't direct.
Yes.
So I filed it, which he has annexed page Lordship, I filed a application
Huh.
before the deputy commissioner.
Deputy commissioner will not give you
No,
maintenance.
no, Lordship, the departmental officer, page 57
Huh.
of the writ petition.
Huh.
There is an order, Lordship, I filed an application because she is not paying.
Right.
As my learned friend is saying that they are ready to pay, Lordship.
Right.
So my resource submission that to be closed on that line, Lordship.
That is what we'll do.
Lordship,
Where is their admission?
admission.
Then why did you want to file a rejoinder affidavit again?
No,
I have filed a rejoinder affidavit.
today he has filed a
Because,
rejoinder.
because my lord, in their affidavit in opposition, she has, the respondent number 8 has made certain allegations that the amount I have received so far, I have not given her her share or her maintenance, which is completely wrong. And on the basis of that allegations, my lord, the family pension was withheld.
Who's
However,
who's for the department? Who's for the department?
however, my lord, now department must have gone through
Elementary-
this, and now PPO has been
who has stopped the pension? Your pension is stopped.
yeah, it was stopped, but now PPO has been issued.
Now it has been issued.
Yes,
So you collect your pension.
yes.
And
And that's why the
that to be-
other day I have prayed for withdrawal of the.
So withdraw it. Let him withdraw.
Lordship, some observation about my, as he has
In view of the full bench judgment,
Lordship, yes.
what observation do you require?
I should have to file application there.
Exactly.
I filed, Lordship, he has annexed. Now he is saying, as per she is willing to ever to pay the entitlement of respondent number 8 in her additional.
That is in regards to maintenance, my lord.
You have agreed to pay.
I have already paid whatever I have received for maintenance of the second wife, and whatever I will receive, I will pay for her maintenance from that amount.
There are two children also, Lordship. Two
Of
children,
course.
minor children.
We are not sitting here to decide on
Yes.
who is to get the
Lordship,
maintenance or
not,
not.
Lordship.
We are to decide whether there is a right called out under the rules read with the judgment.
Lordship,
in
Lordship.
So far as the second wife.
My
is concerned.
only respectful
You have
prayer.
no right. You have
Lordship.
no right. If you are
Lordship.
willing to give on our own,
Lordship, but
your right, if you have, you adjudicate before the competent
Yes,
authority. for
procedure is given at para 23 of the full
That's
bench.
Lordship, my respect to submission. Only I pray, Lordship, regarding that notification of 22, Lordship, on in terms of that
Which notification?
I have
Concern
an
notification.
Lordship, I supply. Notification.
File with it.
I'm supplying, Lordship. 17th August 2022, Lordship.
It's an amendment to the rules, my lord.
Amendment to the rules
143.
maybe, but
It has been issued before the full bench decision, and full bench has taken consideration.
Lordship, that is, sorry, it's marked, flag marked, sorry, Lordship, because I have a copy of that. Last occasion I supplied the same, Lordship. Only following that rule, Lordship, kindly consider the case of respondent number 8, Lordship. Because some years he is accommodating, Lordship. But my
But this has
response
to be read with eligible members. Who are the eligible members?
I am the Lordship family, Lordship. Children are also there, Lordship. 2 children are there. As per next kin certificate, Lordship, annexed there. And they have also in the pension paper, they have submitted the same also, Lordship.
It is not your writ petition, Mr.
Yes.
Counsel.
Lordship, I admit that, Lordship.
If you
She
admit,
is
then please take your
repeated-
seat. Heard learned counsel for the parties.
Then he may be allowed.
The counsel for the petitioner submits that there is an agreement and between the petitioner and the
Respondent number 8.
respondent number
8, Lord.
8, who claims to be the second wife of the petitioner of late Salim Ahmed Barbuya.
Yes, fine.
Barbuya, Lordship.
Stop. Petitioner is the first wife. It is submitted by learned counsel for the petitioner that both the petitioner and the respondent 8 have come to terms and they have agreed to share, and the petitioner has agreed to share portion of the pensionary and retirement benefits with the
For maintenance.
Not
with the
that what
respondent
cannot be,
number
Lordship.
8 for maintenance. Stop.
And 2 children are there, Lordship.
The petitioner therefore does not wish to press the writ petition any further. While allowing the writ petition to be withdrawn, it is also made clear that if the respondent 8 has any further grievance, then the appropriate forum to be approached would be a competent authority for staking a claim for maintenance, as has been held in the judgment rendered by the full bench of this court in Junufa BB, reported in 2023 1 GLT within bracket FP 736. Writ petition accordingly stands dismissed on withdrawal.
Liberty may be granted if liberty may be.
No liberty.
PPO has been issued, but no money
It is
has been.
submitted that PPO has already been issued. Therefore, the authorities are now duty bound to release the pension payable to the respondent number 1.
And also provident fund.
Petitioner number 1 and all other retirement benefits as payable.
And about me, Lordship.
We
if
have
I am
already
a-
stated 23. We have already
Lordship,
recorded.
if I am agreed, Lordship, I may be allowed to approach the honorable court.
Mr. Counsel, we are at the cost of repetition asking you,
Lordship.
have you come before the court yet?
Not yet.
Not yet. So where is
I
the
am
question of liberty?
If Lordship, any adverse order is passed, all right, Lordship, I am agreed on that, Lordship.
You are
You'll have the cause of action.
with great deal of respect and humility.
Sorry, Lordship.
I'd like to point out, remind
Sorry.
you that you are a senior counsel. You are to
Sorry.
leave the court.
Sorry, Lordship. Obliged. Much obliged, Lordship. Sorry, Lordship.
Yes.
May I please, Your Lordship, Lordship,
Transfer.
this matter relates to the
Transfer, yes.
transfer of-
Government, yes, government, what happened?
Records are not available, Lords.
What not available?
In spite of repeated directions.
Now,
of-
now,
As a last son's
is he getting his salary or not?
No, Lordship, not.
He's not getting his salary.
Lordship, I have not got that instruction, Lordship.
Who is supposed to give you the records?
Deputy Commissioner, Lordship.
Deputy Commissioner.
Deputy Commissioner.
I heard Mr. A. Chakraborty, learned government advocate. It is,
As a last
he
one.
submits that records called for has not been received. It is submitted that, it is seen that, as far back as, where were the records directed?
Lordship,
We produced
order there. 25-1. 25-1, 24.
25-1, 2024. 24-1.
25.
The records were directed to be produced, records connecting to the transfer of the petitioner and the private respondent were directed to be produced. However, the learned government advocate submits that he has not received the records as on date. He prays for further opportunity. Stop. Mr. R.K. Dev Chaudhary and Mr. R. Islam, learned counsels appearing for the petitioner and private respondent respectively, submits that the records are required to be produced for proper adjudication of the matter. Accordingly, matter be listed again. When do you want? How much time you want?
20 February.
27th February.
Oh, Lord, what?
By which time, if the records are not produced, consequential orders may be passed and the court may proceed to decide the matter on the available facts, on the available pleadings. The government advocate will endeavor to requisition the relevant records and for perusal of the court if required. Interim order passed earlier will continue. Anything else?
It's taken quite a long time.
Yes, that's right. Because he has not been posted.
You are
in anywhere.
protected by an interim order.
Yeah.
Yes, he has not been.
The
posted in anywhere.
only anxiety is whether the private respondent is receiving his salary
No,
or not.
Lordship, he has been adjusted.
Not adjusted.
No, adjusted, but whether he is receiving his salary.
Yes. It's not been posted.
Mr. R.K. Dev Chaudhary for the petitioner, Mr. R. Islam for private respondent. List on 27th. Yes. Yes.
My lord, here, my lord, we need to obtain instruction, my lord, not to yet receive, my lord.
Huh?
Some time may be granted to obtain instruction, my lord.
Lordship in clear terms directed to reimburse the entire amount. but they virtually set over on appeal on the judgment passed by this honorable court and sanction on rupees 3 lakh.
Where is the judgment of the court?
Lordship, page number 133. Now party is page 154, Lordship.
The amount has not been released. Then why have you filed a writ petition?
But partly complied, Lordship.
Ah,
Partly complied, bills of around rupees 7 lakhs has been submitted.
no. Then why have you filed another writ petition? There is an order, there is already a writ issued. There is a direction to.
Because partly complied, Lordship. Page 161.
You're not understanding. Partly or wholly, there is an order of the court already. Now you want another writ. There is a writ petition, there is a direction by the court by order dated 22/6/2022. Huh? Why are you filing another writ petition?
Because Lordship, I have gone through a judgment wherein it was held that when order is partly complied, then contempt does not lie, it will lie. So
Show us the order. Who says contempt does not lie? There is a contempt will lie depending on what is the direction of the court.
direction, Lordship,
Then
page 154, para 25, Lordship.
re-examine and due verification will grant ex post facto approval and the amount is directed to be released. So, where is the order of release of partial amount?
My lord,
Page 161.
161, my lord.
Page 161, annexure to 18, Lordship.
And petitioner has accepted, my lord.
This is the only amount.
Yes, my lord. That has been sanctioned again to the petitioners, my lord. And remaining, my lord.
What is the claim?
Around 7 lakhs, Lordship.
Okay, then.
Bills were submitted.
So, according to the department, only 3 lakhs is granted.
Yes, ma'am.
No further amount.
Not so, my lord. We need instruction regarding.
Okay. Say that. Mr. Roy, D. Roy.
Yes, ma'am.
Learned Standing Council, Assam Higher Secondary.
No, my lord. Seba.
Seba. Submits that instructions have not, he has not completed his instructions. He'd like to bring for further time. The Learned Council for the petitioner submits that pursuant to the order of the court in the earlier round of litigation, ID or judgment and order dated so-and-so, passed in WPC so-and-so, page number 133. Petitioners have granted an amount of rupees 3 lakhs only in as against the claim of rupees 7 lakhs.
7 lakhs.
Stop. The denial of the claim of the balance amount of 4 lakhs is unjust and therefore the petitioner has approached this court. In view of the submissions made by the respondent council, matter stands deferred for 3 weeks. 3 weeks?
Yes, my lord.
That may kindly.
It will be listed on 6th of March. Yes.
Net please, lordship. FIR on page 17, lordship.
17.
17, lordship.
Yes.
Lordship, after issuing interim order, the petitioner has submitted his bail bond. And similar situated those persons who were charge-sheeted absconder, they were released anticipatory bail from the honorable court.
Where are the orders?
Yes, it is admitted. We got the anticipatory bail after charge sheet.
Who are you?
We are the another case. We are the informant, madam. They filed one case again.
Cross case.
We have lost two brothers.
Cross case.
Cross case. We have lost two brothers.
So in the FIR, in the case registered on their FIR, you have got bail.
Yes.
Only this petitioner is remain lordship. All the petitioners were. They are the suppression.
I am coming.
All the petitioners have been granted bail.
Lordship. Those are absconder lordship. Charge
How many persons are named as accused here?
In this case, madam, there are
Only
so many.
one petitioner lordship.
No, no. total
37.
accused one.
37 or 36?
Yes,
36,
as
but
per FR 36.
36.
somewhere lordship not signed up. I mean,
Yes,
What is-
APP, what do you say?
My lord, so far in this case, my lord, first of all, my lord, the updated LCI is not here, but he was granted interim pursuant to the interim order. Interim was granted after the filing search sheet. He appeared. There is a note from the court below, my lord. And regarding his involvement, my lord, I have gone through the 161 statements of the witnesses. Nobody has specifically mentioned about his name. Specific names were there of some accused persons, and along with that, specific names and some other person. But this person's name is not specifically mentioned in 161. I have not at least not found my lord in the receipt.
Where are these statements?
There is LCR, my lord. And my lord, but the search sheet was late, showing him absconder, my lord.
after filing search sheet, this bail petition was prepared. Your lord.
This is that people murder case, my lord. I remember. Your lord.
One person died from our side and 2% died from informant side.
But another interesting thing is that they have all these things, accused got suppressed. Your lordship rejected bail earlier for all the accused. They have suppressed it before and got a bail suppressing your lordship order from my Lord Justice Kolita.
Have you filed an application for cancellation?
Yeah, we have filed cancellation of that in that court is pending.
All right, then let both the matters be listed together.
Kindly, madam, I'll show.
It will be better.
It can't be listed together because
Yes,
these
yes.
are on different issues.
Yes, yes. But
And,
as your lordship has
There is
passed
a
on, it
recent
have to
order
come
of
to-
the Supreme Court.
Lordship,
Yes.
I have also.
Yes.
I have to obtain.
Where is that? It is Supreme Court or order.
Yeah.
On 19th
Ah.
January.
So there is a clear direction.
Yeah,
now.
there should be specific regarding earlier bail petition whether rejected or pending.
Then
They have suppressed lordship. But
They have, you have suppressed.
no, lordship. This petitioner is annexed earlier rejection order, lordship.
No, yeah, here you have, but there you have not mentioned.
We are
That
not
your
that-
lordship were rejected.
Lordship, we are not the advocate on that case, lordship. I'm only this petitioner, lordship. In page number 28, lordship, I have annexed the earlier rejection order, lordship. Kindly see my bail petition, lordship. Page 28, lordship.
And it is after charge sheet, madam, earlier rejected by your lordship. After
What
closure of the series.
What about the APP? What do you say? That there is an allegation of suppression of the earlier orders?
My lord, that case I don't remember that. I have to see the record.
You have to now, in the view of this judgment,
Yes, both should be
you'll have to
taken
take
together.
steps if required. Where is the earlier order?
Page 28, lordship, in my
28.
lordship.
Yes.
And petitioner number 2 is the present petitioner in the second bail application, Lal Bahar Ali. But they have suppressed, they have already got absolute bail, lordship.
No separate, we have not.
No, যিবিলাকে কৰিছে
সেইটোৱে কথা একেবাৰে এই অনাৰেবল কোৰ্টৰ অৰ্ডাৰটো সাপ্ৰেছ কৰি লৈ ল'ল
গম পাইছে সেইটোতো
কিমান সিৰিয়াছ এলিগেশ্যন
lordship we are not for that person, lordship.
His submission is that for wrongdoings of some other person, he should not suppress.
Yes, that's true, but that's true. That's true. But my only prayer is that your lordship earlier perusing.
But then at the same time, you are relying on this order.
Yes.
Lordship,
yes.
This bail petition is pending for long time, that's why.
Which means you know that there was a suppression at the
No,
time
no,
of
Lordship,
granting this order. Where are the statements? Where are the orders? Please find out, mark it for us.
Those are
Is it
marked.
marked?
Those
Is
are
it marked?
marked. That's a separate file, man. There are three files.
Marked for debut.
That amount is not here. At that time, his bail application was rejected because charge was not filed, considering the slip.
Early stage of investigation, that was reflected in the order, Lord.
দেখাই দেব না, খুলে দেব।
These are marked.
Oh.
Those are marked.
Which are the, where are the statements?
Below portion.
What is his name?
My
What is his name?
Lal Bahar, my lord.
Lal Bahar, yes.
Lal Bahar.
Yes, their statement. দেখে বাকি
160 or 160. There is actually
আমার হাতে পোৱা নাই তেও
No, পোৱা নাই, তাৰ ইনফৰমেন্টও পোৱা নাই।
No, this is the charge sheet which you are pointing out. Where are the statements? There are no statements.
my lord is asking about his statement or other one.
His.
But he is absconding.
his statement is not there because he
You
was
are on interim bail?
Interim bail, I have appeared before the court below lordship
Huh.
and submitted bail bond lordship. And interim protection was get after filing charge sheet lordship. That's why I'm appeared before them. And additional affidavit was filed in.
No, you arrange it properly. They're all messed up. Arrange it properly, sequentially. Give it to us at 2 o'clock. You give it to us. Arrange it properly.
Otherwise, his statement is not available here because this is the city portion. And he came before this court after filing.
What is the status of the trial?
My lord, that is not up to date. That is not up. That's why.
Then let us call for it up
Yes,
to date.
my lord, that's why I-
Scan copy.
or he may go there also approach my lord.
He's on bail.
Yes.
I'm regularly appearing.
After hearing the counsels at some length, it is seen that up-to-date case records from the concerned court is required to be called for accordingly. Registry is directed to
আমাকে একটা কপি দিবে স্যার।
call for legible scan copies of the what is the case number? What is the case number?
That PRC number 1420.
PRC number 1420 of 2023 from the Court of Sessions. Has it been committed?
My lord,
He's not been committed as yet.
but that is not reflected from the just in the early stage.
Board by time.
PRC case number 1420 of 2023 corresponding to Sorbog Police Station case number 31 of 2023 under section so and so, comma, from the concerned court before whom the matter is presently pending. Let the scan copies be made available. Let the matter be listed after receipt of the scan copies as called for from the court. Matter be listed again on th. It's eleven March.
So can in 12
11 March.
12.
12th. Not 12th, then 13th of March.
All right, my lord.
Interim order passed earlier will continue.
Interim maybe.
Continued. Yes.
Mayor, please, or not.
May I please, Lordship? Lordship, I'm praying for pass of the matter for time being, Lordship. Matter may be fixed at 2.
Not two. What is the matter about?
Matter is about my lord, they are seeking to recover an amount of rupees 7 lakh from the death cum retirement gratuity of the petitioner, my lord, because of the alleged overstay in service for about 13 months. My lord.
What was the petitioner working as?
Petitioner was appointed as an extension officer. Later, he was promoted to a post of BDO in the PNRD department. And there is some anomaly as far as his date of birth is concerned, my lord. At the time of his initial entry, he has submitted his admit HSLC admit card, which have recorded his correct date of birth, on the basis of which the service books were prepared. But in spite of that, my lord, the gradation list was prepared in the year 2007-15, my lord. In that gradation list, his date of birth was wrongly recorded, my lord. So because of that, he was asked to continue for additional 13 months. And during these 13 months, he has rendered his full service, my lord. And they have utilized their service and he was paid salary, my lord. Now they are seeking to recover the amount of rupees 7 lakh from his death cum retirement gratuity. Although the recovery has been stayed, but the amount is lying with them and they have not released the amount. In fact, we have intimated them that we are about to retire. So we may be retired on, which is the actual date of retirement, my lord. But we were asked to continue for additional 13 months.
Okay.
His actual date of birth as per his service book is 18.
Get upon some other date. Who is appearing?
Lordship, I'm appearing for Accountant General. Lordship, my senior will argue the matter.
Who?
Mr. A. Hassan.
Mr. Hassan. Matter be
Today
posted.
is some medical emergency, Lordship.
Huh?
Today, due to some medical emergency,
Matter be listed some other date.
Lordship.
The date may be fixed.
20 matter, it should go for part 2 matters.
Part 2.
20 matter.
2020 matter, my
Then
retired.
we have to give priority to other hearings, old hearings.
He's retired in the year 2017, my lord. But till date,
He's not getting his pension.
He's received the pension, my lord. After
only
filing
that
of the
part.
writ petition, they have dispersed the pension for those 13 months. Also.
Only for that particular period
He has received the
amount he has
pension
not
later.
received. All right. Have it after 1 week.
Mine.
Yes. Matter be listed after 1 week, as it is submitted. Mr. A. Hassan, counsel appearing for Accountant General, is not available in court because of personal reasons. Yes. Mr. Dewan.
M. Dewan.
For the petitioner, then Mr. Rabha for Accountant General, Mr. Hendik for PNRD, Mr. Borpuzari for Finance. Anyone else? All right. Yes, this
Let the matter be passed over for time being.
next week. Next week.
Item number 30, Lordship.
Yes, next week.
My lord, next week, my lord, from 11 to 69 may not be available, my lord. So 28, my lord.
After 2 weeks.
My lord?
After 2 weeks. Matters be listed after 2 weeks.
2 weeks.
30.
Yes, 30, I am appearing. Oh, sorry.
You are making a prayer for item 30 also.
Item 29, 30, yes. Lord.
29, 30.
After 2 weeks, next week, I have some difficulty.
After 2 weeks, a joint request. Matters be listed for it.
Okay.
You see, by this impugn notice, that fails is page 19, Lordship. By this order, Lordship, they have not stopped our services. They have allowed us to work, but they have stopped the salary.
Because of your subject conference not being available.
Subject concurrence was
Subject conference were done later,
later.
after 1/1/2006.
Yeah. It was, our stand is that it was a continuous process in terms of the school concurrence, school recognition, lots of. It took some time, lots of, and lots of, there was sufficient enrollment in that particular subject, and the results were also satisfactory.
Yeah.
And there are also 3 rounds of verifications at the district level and the state level. And lots of, in fact, lots of, there is an amendment proposal in 2012. Lots of may kindly come to page 23. Page 23, it is a type copy, lots of. To be clarified, lots of, in case of junior college which have established, obtained permission concurrence from the concerned authorities on or before 1/1/2006, but subsequently obtained government concurrence on subjects from the state later on, the subjects be considered along with the respective institution for coming into force of this act. So this probably was not incorporated when this 2017 act was come into effect. That proposal was already there in 2012. And this is in the spirit of this amendment proposal, perhaps in the verification process at the district level and the state level, our services were provincialized in 2021. And after serving for long 13, 14 years in the defense state.
Yes. Same view is reflected in your affidavit.
My lord, the stand is reflected in our affidavit. What has happened is, my lord, these junior colleges, this what the amended proposal that has been brought to lordship's notice. My lord, there was a Assam Junior Colleges Provincialization Act 556 of the book. I just got my notice. We can read it out.
856.
My lord. If lordship has his writ petition, he was referring to page 23. Now, this page 23 is amendment to be required to the Assam Venture Educational Provincialization Act 2012 for junior college. Now, there was a act of the Assam Junior Colleges Provincialization Act 2012 at page 556 of the book.
Junior colleges provincialization. Then
It's one of this Provincialization of Services Act 2002 for junior colleges. That was a separate issue altogether. That lordship would not bring it into the 2007 applicability in the 2017 act is what I'm trying to say. This amended whatever is being shown. Now, my lord, the definitions in the 2017 act, if I may refer to, my lord.
Page 114.
114.
this is for provincialization of junior colleges under deficit, which were already under deficit system.
The page 200, page 23, which was referred to the proposed amendment on all matters, that referred to junior colleges provincialization. That junior colleges in the year 2012, separate act was brought in for that. Now, my lord, that act has been repealed. So any amendment
Which
proposed
act
was for that act. Now 2017, if lordship would have.
Which act has been, so this is repeal.
This is repealed also, madam.
And then there.
So then all
is
any amendment proposed there or here would not make any difference to the present case is what I'm trying to impress. Now lordship would kindly have page 100 and 108.
Of the book.
Section 3.
108.
Of the book, madam.
Yes.
Or prior to the matter, page 106. If we just say, madam, page 106. Clause Z. Venture Junior College means a venture junior college established by the people of the locality prior to 1106, which has received concurrence from the government and permission from the Assam Higher Secondary Education Council on or before 1106. And wherever the service of the teachers have not been provincialized under any act. So here it said that which has received the concurrence from the government. This concurrence is explained at page 108. Section 3, subsection 1, proviso. Provided that the permission for the first year HS clauses in respect of higher secondary school. Next, concurrence for first year HS classes in respect of senior secondary school, erstwhile junior college. Recognition from Board of Secondary Education for class 9, this will not be important. Received from the government on or before 1106 shall be treated as the permission, concurrence or recognition as the case may be for the purpose of provincialization of services of teachers and tutors of this act. Provided further that the order for such permission, recognition or concurrence shall have to be issued on or before 1106. Any order issued thereafter with any retrospective effect shall not be considered for the purpose of provincialization. Now, my lord, when the clause of the, when this particular section of the act itself defines that there has to be, and then lordship would like to come to page 112. Page 112. This is a part of the same section, section 3, which is part of section 3, subsection 13, subsection 2. May I read, my lord? Page 112. In case of a venture degree college and a venture higher secondary school or a venture junior college, the eligibility criteria specified in subsection 1 above regarding the date of recognition, affiliation, or concurrence, minimum enrollment and performance would mean in the respect of each of the subjects with or without major. But one part, I may be reading the wrong part, but it was a subject-wise, my lord, concurrence was also there, my lord. That when we talk about the concurrence, we talk about the this is minimum. Will give me just a minute. I failed to trace it out, but there was a condition that it has to be on a subject-wise basis, the concurrence has to come.
No, but is this
No, they-
clause 2 not clear? Criteria specified in subsection 1
One.
Regarding date of recognition, affiliation or concurrence would mean in respect of each of the subjects.
Each of the subject, with or without major as the case may be.
So each of the
And
subjects.
So
there
each
has
of
to
the
be-
subject has to have the minimum number, the date of concurrence will be taken into account for provincializing a person in that category, and the minimum number of students or whatever other criteria is there, it has to be on a per subject basis. Now, my lord, when the petitioners' cases were forwarded, then lordship will find that when the petitioners' cases were forwarded and verified and whatever stage was there, my lord, admitted position remains that they did not fulfill this particular criteria. Their concurrence on their particular subject did not come prior to 11/2006. It is also the admitted position that they were in fact provincialized. Orders have been issued to the effect of their provincialization. Now the issue only remains, my lord, whether we can correct our mistake, and if that mistake is corrected, in what manner it should be done. So, my lord, if the entry into service is found to be not correct or not legal, my lord, there are Supreme Court judgments to the effect which says that there is no requirement for such backdoor entry, termination of services of such backdoor entry
No,
entrance, my lord.
this cannot be termed to be a backdoor entry.
My
It
lord,
is a question of the time of saying this particular aspect was overlooked.
it was overlooked.
Perhaps the concurrence was sought for in respect of the school. I don't know.
But the
on
entire
what
school,
basis.
the concurrence for
date
the
of
school was taken
affiliation,
into note of in all probability
instead
without
of subject wise.
not taken up subject wise.
Now these teachers are in respect of what subjects?
My lord, these teachers, they all belong to different subjects in different repetition, if I'm not wrong, my lord. And the lordship will also find that their initial appointment.
It is PGT anthropology.
All of them?
Sorry, Lordship, PGT advanced Hindi.
All
The
of
present-
them?
Now-
This petition Lordship, it pertains to PGT in advanced Hindi.
Advanced?
There are other subjects also.
No.
Different subject.
So far as the petitioners are concerned, their grievance is, their concurrence which has not come is with regard to only one subject.
Only one subject. PGT advanced Hindi.
Oh, well, what happened is, for the college, other
No,
subjects.
In other writ petition,
No.
they are
No,
Different
in,
subject.
in this writ petition,
in this writ petition, it is for advanced Hindi.
advanced Hindi.
Advanced Hindi. Now, lordship would like to have their orders of provincialization at page 17 of the writ petition.
Yes.
In the provincialization order, at para 5, lordship will find if any of the information found incorrect or false at a later stage, the order of provincialization shall stand cancelled immediately. Now, my lord, what the department has sought to do is, we stop the salaries because information was found to be incorrect. The entire provincialization was not cancelled. Stop the salaries, and we try to bring about either a solution or to give them a support. Now, that period within which we were taking the decision, because once the salary is paid, it is difficult to recover. At that stage, they approach this honorable court. Although per terms of the contract of appointment itself, the terms which they have accepted, for those terms itself, it should have stood cancelled immediately.
No, but in your letter, in the order at page 17,
My lord,
the conditions mentioned are very specific. They have fulfilled all the conditions.
so if any of the information is found incorrect at a later stage, the order of provincialization will stand cancelled immediately.
No, if any of the information found is with regard to those which are specified,
Yes, my lord, for everybody, it was the same sort of an order. This is a institution-wise order. It is the same sample order in every petition.
so now the cancellation would be with regard to what? The teachers? Of
The
this-
particular teachers, not the whole school. The particular teachers who are found not to be eligible for the aid, their cancellation has to go. We do not cancel the whole school as a whole. So therefore, we
No,
stop.
you have to come back again. This provincialization is in with regard to what? Teachers,
Lordship,
not to the school,
not of the school,
only the teachers,
only the teacher.
irrespective of which subject they are teaching.
Yes, particular
So
teachers.
therefore, under your Provincialization Act, you have made a classification as per a schedule that many number of students in this class, one teacher, two teachers, science teacher, is that all these things are there.
That is.
Now, insofar as subjects are also concerned, there must be concurrence prior to 1/1/2006.
Lordship will just allow me to make one clarification. Schools and junior
junior
colleges.
college.
So here we do not go by the concept of PTR or the number of students, we don't go by that concept. We go by the concept that once an institution starts, it has to take a permission from the higher ESSEC and it has to take our concurrence. Now, if they have got the permission from the ESSEC or the concurrence from us for the first year classes, we take it to be, if it is prior to 1/1/2006, we take it to be okay. We consider it. Now, this concurrence has to come subject wise because there are colleges which only give a few subjects. Someone takes a concurrence for SMEs and two other economics and something. Third college will try to say no. Now these people would say that no, we also want a concurrence for Hindi. So they'll apply later and they'll get it later, provided the permission comes from the higher secondary ESSEC, that is the Assam Higher Secondary Education Council. So in that particular subject in which the petitioners were holding the post, particular concurrence of the particular subject came after 1/1/2000. So therefore, the institution as a whole does not lose the right of provincialization. The particular person serving in that post, he goes back to school. The petitioner's case is that once we were provincialized, we have an order of appointment. You cannot stop the salary without a notice to us perhaps,
No,
or without having a due
but
verification.
the remedy will not be stoppage of salary.
True.
Remedy would be to correct this anomaly which has occurred.
Either
number
we
one,
cancel the entire
or you cancel
provincialization.
the entire process.
We cancel their provincialization because the information found is incorrect. Lordship will find it 5. If any of the information found incorrect or false at a later stage, the order of provincialization shall stand cancelled immediately. Now, at the next page, page 18, Dipti Pator, Punima Botakur, Besbora, Amit Bharali, Shiv Chetri, Manas Giri Taluda.
No, now their provincialization is in respect of which 2017 Act.
17 Act.
Where is that Act? Let us see.
Lordship, that is what I had read up on page 1 of
Yeah, 17 already. Okay.
That is what I had read. That concurrence has to be subject wise. Their subject did not have the concurrence. Lordship should perhaps only determine as to the manner.
And why the 2018 Act is referred?
18,
This for
2018
non-teaching
Act is
staff.
referred because there was a amendment to the 2017 Act by an 18 Act.
No, 18 is for non-teaching staff. No.
Non-teaching staff, there is another act.
There's another.
There is another act.
For the purpose of this case, we are not concerned with that Act.
Here, Lordship will find at page 18, serial number 6. Poinita Pator is the only person, if I'm not wrong. Poinita Pator, the PGT advanced Hindi tutor. She is the only concerned person. The rest of them, the concurrence and everything was found fine. So we are not disturbing any of the others. We are only disturbing Poinita Pator. So if we go by the appointment
Now,
letter,
this information, according to you, is there any finding that it was wrongly placed, suppressed, or anything like that?
my lord, if that information is wrong, is also the stand in the repetition, my lord. I need not go ahead to say that they admit that the concurrence came after 1106 for that particular subject. There is no dispute to that.
Now, what remedies do you have?
Now, my lord, for the appointment letter itself, the provincialization stood cancelled on the date we found the mistake. And therefore, no salaries from that day on. That was a term of appointment, my lord.
What is the name of the Act again?
My lord, the Assam Education Provincialization of Services of Teachers. Lordship would find at page 10.
And reorganization.
Page 101, my lord.
10.
That's from page 99.
Okay. Yes. What do you say?
Lordship, the page 24, which I have told before, Lordship, with regard to the proposed amendment, that Lordship pertains to section 3 of the 2011 Act, not the Act which my learned friend has known. If you Lordship again comes to page 24.
No, how is it relevant in the context?
How is it relevant? Now, Lordship, in this present batch of repetitions, our prayer is to pay our salary because we are working. Our services have not been disturbed. And Lordship, subsequently, we have also filed a writ petition challenging the virus of section 3.2. And that matter came up before the division bench, and it is again fixed on 19th of
You're challenging 3.2.
3.2, the virus.
No,
but in our present, this batch of repetition, Lordship, we are challenging, Lordship, that because our services have not been disturbed, we are it amounts to forced labor.
Your answer probably lies
Lordship.
in section 15, page 123.
Page 123.
123, section 15. In fact, 124, clause 2 of section 15.
No, that's a different thing, Lordship. Our institutions have been provincialized before 2006. The institutions are
No, your
established.
provincialization will have to be as per section 3,
Yes.
3.2.
Section 3.2.
3.2 says subject-wise concurrence.
Subject-wise.
So it is your case that your subject was did not receive concurrence.
Lordship, our stand is that, Lordship, that it was a continuous process. There were communications, Lordship, although it was applied before 2006, but when the subject concurrence was finally received, it was after 2006.
What about
So-
the other subjects?
Other subjects have received the concurrence prior to 2006.
Then
Yes.
where is the communication by which concurrence was sought for?
In this writ petition. Also, the government concurrence, Lordship, I have annexed at page 20, Lordship.
20.
Page 20.
This is concurrence.
Concurrence.
English, MIL,
English,
Assamese,
MIL, Assamese, Advanced Assamese.
Hindi is not there.
Hindi, that was received after 2006.
Where is that? Hindi, next page.
No, that is the next page, Lordship will. find is
Geography,
for
history,
additional subject in-
Hindi and advanced Hindi.
Lordship will always
Page
also
21.
notice it is for the second year. The first year concurrence must have come before that. Otherwise, the second year is not allowed.
So, page 21, Lordship.
21.
This is concurrence or permission to start additional
Second year.
subjects in second year.
Second
So
year.
the first year concurrence has to come.
So, first
That
year
page is
concurrence,
missing.
first year concurrence will even come prior to 2010. First year concurrence will even come prior to 2010. This is the second year concurrence. Lordship.
That's right.
The petition has collected whatever they have, Lordship, because these are all official communications. College used to send these proposals to the government, then Lordship to the Higher Secondary Education Council.
If you look into the last line,
Lordship.
it says it is in continuation with department's letter number so and so,
31/3/2005.
31.3, which is the previous page.
Yes.
So does it mean that there is no concurrence at all?
No, it is the concurrence has been received, Lordship, on 6/5/2010.
No.
Lordship,
that-
my subject is also there, advanced Hindi.
All right, let us presume that first year is also granted
Yes,
by
yes,
default.
yes.
But then it is 6.10, 6.5. 6.5. So it cannot be said that this is an extension of 31.5, 31st March.
Lordship, it has been written that this is issued in continuation of this department's letter dated 31/3/2005.
So you show us that all these subjects were applied together and the concurrence was issued in part. First part came on 31st of March 2005. Second part came on 6th of May 2010. Then perhaps you may have a case. Mayor's statement will not do. You'll have to find out.
Lordship, may kindly see page 22, Lordship. I have also given a chart that has been issued by the principal, Lordship.
Hmm.
From 2005 to
year 2005-6 also, Lordship. Their enrollments are.
Government, I think you need to find out when the concurrence applications were filed of the college.
Per case, my lord.
At least.
We'll have to come back with the per case chart.
No, because see, if you look into 31st March 2005,
Yes.
this is according to you, this concurrence is as per the norms.
My lord.
And subsequently, 6th of May 2010, these are the subjects including Hindi and Advanced Hindi.
Yes.
But this appears to have been issued in continuation of the departmental letter dated so and so, which means that perhaps
There was an
pursuant to
application.
31st of March, this is the only letter. This is one. Or can it mean that the concurrence was put up together, but one part came in 31st of March, second part came on 6th of May?
Now,
in that case, their right for being considered as having to have the effect from prior to 1/1/2006 may be sustained.
my lord, when on the face of it, on the documents produced by the petitioners themselves.
We agree, but we want you to look into these facts and find out what is the status, because see, they are teachers. They are employed by the management. They have no idea when the documents went, who's given the order. They are concerned with their jobs. They are selected by a process. They are working. They are getting their salary. Suddenly, in the middle of nowhere, the salaries are stopped. Yes.
Lordship, our current salary may kindly be released, Lordship.
Cannot be unless you satisfy that the hurdle of 3-2 is overcome, because otherwise, you see, you don't seem to realize, because supposing your writ petition gets rejected, including that writ petition for challenging the virus, and there are materials to show that concurrence indeed for Hindi was given after 1/1/2006, then there will be an order for recovery. Would be.
Lordship, there are also judgment, Lordship, that if we are working, Lordship, that salary cannot be denied to us. We are working, Lordship, till that. Our services have not been disturbed.
We don't want to defer the matter for long. We don't want to extend your agony for long. We want them to find out and tell us what is this. Otherwise, the management will have to pay your salary. Whatever the management is supposed to pay. Anyone, have you arrayed the management?
No.
Management is not there. Yes, finance, anything to submit?
Lordship, my learned friend will make the submission.
No, we'll take up. The issue is the same, isn't it? Factually, subjects could be different, date of approval, etc., different, but the core issue is that all these concurrences came after 1/1/2006. Right? So let us hear the finance if they have anything to submit. Yes, finance, anything to submit? Anything more or any addition to what Mr. Mozumdar had submitted?
Your concurrence was there.
So far as provincialization is concerned, my lord, that is, my lord, done by the, my lord, it is concurred by the finance department on the basis of, my lord, the proposal, my lord, submitted by the concerned administrative department. Here is a case, my lord, where, my lord, the provincialization and other things, my lord, for all the employees, my lord, that has been done, my lord. It has been done on the strength of the proposal. The data that has been, my lord, sent by, my lord, the administrative department. That is the school education department for the present case, my lord. Now, my lord, so far as
All these are without specific details, you see. It is on the presumption that the data is correct, isn't it? We are trying to find out what information was put up before the authorities in respect of these particular petitioners.
that, my lord, we have communicated to the my lord, finance department. The finance department at one point of time, my lord, they requested, my lord, the secondary education department to furnish all the documents to the finance department. Now,
No, what documents?
my lord, to my lord, avoid the statements and avoidance made in the writ petition. Because in the entire series, my lord, only in 2 writ petitions, my lord, finance have been implemented as, my lord, party respondent. In other matters, finance is not implemented. And in one matter, my lord, that is, my lord, WPC, my lord, that is 768 for Mukul Sharma. My lord, that is.
As also in this writ petition, 7317.
Yes, so there, my lord, we got for the instructions, my lord, from the finance department. The finance department has in turn, my lord, communicated, my lord, to the secondary education department, my lord, to furnish relevant information documents. Now that is, thereafter, my lord, nothing is forthcoming. So this is how we stand. And my lord, so far as the issue of my lord, earlier salary, that is within the domain of the administrative department concerned. This is my respectful submission.
Yes, Mr. Mazumdar, they are without salary from 30th April or 1st of May.
My humble my
From 1st of May,
Yeah.
22.
The day it was found that it was wrongly provincialized.
We agree
announced
with
the
everything, but
appointment
you have
by the-
not taken a decision.
My lord, we need not because because at
No,
clause
but then you
5
can't stop their salary.
my lord, clause 5 their provincialization stands cancelled.
Where? Where have
Clause
you
5,
cancelled it?
Page 17, the termination the offer of appointment itself.
Where?
Page
17.
17,
Ah.
para 5. If any of the information found incorrect,
Oh, that can't be unilateral. You
the
have to, you have
order of
to.
provincialization
No, no.
shall stand cancelled immediately.
No.
Now, if
Otherwise, you see, your affidavit says otherwise. Kindly see. The affidavit which you have filed which has been filed by the director.
Yes.
If you come to para 9, page 39. The matter has been referred to the government for seeking instructions.
Yes,
So
but
how do you
whether-
say that it is stands cancelled?
It stands cancelled, and the director saying that this entire issue is also forwarded to the government. But it does not mean that we are trying to even come to a decision now. It
No,
may be also a
no,
reference. Lordship will find
There is no power for the director under the act
that the
to
director
show
was-
that it gets unilaterally cancelled. You'll have to arrive at a finding. You'll have to arrive at a proper finding that this is contrary to the provisions of the act,
that
and
lordship-
therefore their provincialization stands cancelled.
that lordship will find.
Where is that finding?
Lordship will find. My lord, the next parameter, page 40.
40.
Page 40 is another,
Yes.
where we have stated it is because only of this.
Where is it?
Or at page 36 also, page 40, para 10, matter, the department is as per a section so and so, venture which have been established so and so. As the case
Department
may
has a right to cancel. That's all. Kindly come to the last line. Salary stop. That's all. There is no categorical averment. There is no order showing that their provincializations are cancelled. The department is not. This is the affidavit filed by the director.
Now, in fact, my lord, at page 36, I
You have stopped payment of salary and referred the matter to the government and forgot all about it. So we'll have to wake you up now from your deep slumber.
Lordship will give me a week's time, my lord, I'll just try to find out because Lordship will find at page 36, paragraph 6 of my affidavit, we have stated that we have taken a hearing of the petitioners and all.
Who submitted, what documents? You can't unilaterally cancel them without putting them to notice. They don't even know what documents were relied on. And you expect people to work without money. Management is not, why have you not arranged the management a party? Are you scared of them?
Because our appointment was much earlier, Lordship. Because we are appointed.
There is no management now.
We are working in the Venture space, Lordship. We are working from the Venture space.
No.
We are receiving some
After
nominal amount.
provincialization, it is reconstituted, is it?
Reconstituted.
Yes.
We take over, my lord, the SMDC.
But there
and
is
the
still an SMDC.
Yes, there is.
So they ought to have been made a party. It appears you are scared of the SMDC. No,
No.
not scared. All right. Mr. Mozumdar, please get the instructions. This is not a cancellation order. This is an order, plain and simple, stoppage of salary. And the matter has been referred to the government for last 2 years. Or we close the matter directing the government to pass an order.
Lordship could make it time bound because they are waiting without salaries, they should know that. Lordship will give a
Of
time
course,
bound
we'll make
because
it time bound, but
at least they can come, or they can at least be satisfied that our job is done. Either of the two.
we will close the matter, remanding these, who's the authority secretary?
Secretary would do.
Secretary to take a decision vis-a-vis the status of the provincialization of each of these petitioners
Hello.
by giving them proper notice. And till that is done, they are entitled to the salary. We are interfering with this order.
The order, my lord, at
3012, 34. And if their cases are found to be genuine in terms of the provisions of the Act, then whatever area salary you have stopped, that also you have to release.
my lord, in case it is found that they were not entitled to the.
They were not entitled, you take.
Then this period, whether they have actually rendered service, not service, all that verification has, Lordship would give us that liberty at least.
We'll give you that
So once the
verification,
salary is stopped, whether they have come to the college thereafter or not.
very well, so you verify and release their salary. But this order has to go. Their salary will be stopped only if their provincialization is found to be not in order. That order has not been passed till date. So you have stopped the salary. And you are trying to project that by clause 5 of that order, deeming fiction, they're deemed to be terminated. That can't be.
That is my
More particularly reading the averments made in the affidavit.
that it was only the salary which was stopped and it was
Yeah.
referred. Lordship will have it.
Yes. Anything to submit?
What my friend is saying regarding clause 5 is in respect of clause 4. We don't come within that clause 4.
Even assuming we adopt his interpretation that clause 5 will operate with reference to clause section 3(2) of the Act, then also there is a requirement of putting the persons to notice.
And putting them to notice was one aspect, my lord. Even I had discussion with my friend, my lord, that a notice is missing in this case. That I have also seen. Now, my lord, may I pay it this way, my lord? The Lordship will give the shortest possible time for taking a decision.
How much time?
Lordship will give us, say, 45 days, my lord. And my humble prayer, my lord, till that time we do not release the salary. Based on the decision, if they are entitled to salary, it will go within the next 1 month or so. And if not, then we let them know. Another 45 days or 2 months would not matter. But our recovery.
Let us understand one more thing.
My lord.
Assuming you come to a finding, yes, whatever is available in your letter at 30th of April,
My lord.
This is the correct position. They would not have been regularized. Now, what are the options available to the school and the teacher? They will not be treated to be provincialized, but there is no bar for them to work without being provincialized for that particular subject in that school. And then it is the SMDC will have to now decide how to pay the salary.
They make a claim to the SMDC, my lord, I would have no difficulty for that period. For that period, if the SMDC is made, I have no difficulty.
No, provided you come to a finding.
Yes.
That finding is not here today.
So possible only, my prayer was, my lord, on the decision, either we give them as arrears, or we give them, or we deny them everything.
My lord, one thing.
Even that is the position, my lord.
Cannot pay. SMDC cannot pay, it's sure. Because earlier they used to take the fees from the students at the venture stage for a nominal fees. After provincialization, that is also cut off. Secondly, the SMDC is nominated by the government.
Nominated, it is elected.
No.
Sorry.
What
It is selected and elected. I'm sorry, that is what the law says. It is
Yeah,
selected and
that is the reason
elected.
I'm saying.
It is not appointed.
It's a selection made by the government.
How can you?
Obviously.
Nomination.
No, your arguments, councils, your arguments are to the court, not to each other. Make your arguments to the court.
But the selection is nowadays the selection is nominated by the.
We are only trying to be a little concerned with the teachers who have not received their salaries in spite of, according to your submissions, that you are getting it. Now SMDC is there. There is an SMDC in terms of the act. The SMDC is supposed to look after, they will make arrangements to release your salary. But you have not made them a party. You have not made them a party. Because it is the SMDC comprising of the principal, who is perhaps the secretary of the SMDC, who's responsible for furnishing all the documents before the authorities for provincialization. What documents were sent, what concurrence letters were sent, how it was done, all these things are not before the court. Yes, you'll have to give us a list of the writ petitioners vis-a-vis the subjects. You have? Yes, yes. Eta number add করবে তো।
I can know 14 to add.
From May 2021. Here got the job, and that also pilot tutor, 10,000 something.
Your prayer is okay, but the specifics of the act, very clear. And it is because of which, you, according to Mr. Das, you have put a challenge to the virus.
What I'm saying is, you are working, let us survive and work.
You may be working, but the government, as it stands today, if your concurrence is not prior to 1/1/2006, they are not entitled to pay your salary. SMDC may be. But you have not arranged them a party. Assuming we pass an order, it will be in their absence.
My daughter pointed out at one point of time why this acquisition was going on. They have only stopped the salary, but they have not taken any decision.
That's right. That is what we are directing them to do. Yes, Mr. Mazumdar and Borpuzari. We'll dispose it of. 45 days. You decide. And take necessary orders, and if you think it is illegal, you will have to give them notice. And that again is a time-bound project. You can't go on for eternity.
My lord, only my lord, two prayers, my lord. The first prayer, my lord, they will, my lord, approach the secretary to the department, my lord. They will, my lord, submit their individual claims, my lord. Let them submit their individual.
No. They are not required to submit. It is already before the authority.
Already before the office.
It's already before. Heard learned counsels
Then,
for
my
the.
lord, then, my lord, second aspect will play, my lord. My lord, if for the interim period, my lord, till it is decided within 45 days, lordship may not direct, my lord, to release their current salary because they may not be entitled.
We'll see. Let us, you hear the order. We are declaring it now.
Yes.
Heard learned counsel for the parties. This writ petition is disposed of. This writ petitions are filed by the petitioners who are subject teachers in their respective junior colleges, is it?
Now it's called senior secondary school.
Senior secondary
First class
school.
junior college.
Stop. The factual position in all the writ petitions are largely similar, bearing the individual dates for appointment and provincialization and grant of salary, etc. Stop. The writ petitioners claim to be working in their respective schools, which were earlier known as junior colleges and now reclassified, renomenclatured as senior secondary schools since the venture stage. Stop. The government of Assam, by the Assam Educational within bracket provincialization of services of teachers and reorganization of Educational Institutions bracket closed Act 2017. Provincializes the services of teachers and obligor tutors of those institutes under the terms and conditions specified under the various sections of the Act. Stop. The procedure prescribed for the eligibility criteria for selection of teachers, selection of educational institutions for provincialization of the services of the teachers slash the tutors are specified under section 3. Stop. Proviso to section 3 within bracket Roman 1 specifies inter alia that concurrence for first year higher secondary classes in respect of those schools are to be received from the government on or before 1/1/2006. Stop. On the basis of such permission, concurrence or recognition required to be received by the respective schools from the government prior to 1/1/2006, the process for provincialization of services of teachers or tutors will the orders for provincialization of services of teachers and tutors will be issued under this Act. Stop. It is also provided that any order issued after 1/1/2006 in respect of permission, recognition, or concurrence by the government shall not be considered for the purpose of provincialization of the services of any such teachers with any retrospective effect. Stop. Under section 3(2), it is provided that recognition, affiliation or concurrence, minimum enrollment and performance are to be in respect of each subjects with or without major, as the case may be. And it is and the services of the teachers appointed or engaged in connection with such subject or subjects shall be considered for provincialization under the provisions of the Act. Stop. The petitioners, having been appointed in their respective schools and rendering their services in the various subjects since the venture stage of the schools, their cases for provincialization were put up before the government along with other teachers from the said school in respect of other subjects. Stop. Pursuant thereto, the orders were passed by the competent authority in the government, and orders were passed on 4th of February 2021, whereby the petitioners, all the orders are 4th of February.
Provincialization orders all.
4th of February, whereby the petitioners were provincialized in their respective subject. Stop. Pursuant to the order dated 4th of February 2021, the petitioners have been receiving their salary as per the scale prescribed in the provincialization order. Stop. While the petitioners were rendering service, the Director of Secondary Education by the impugned order dated 30th of April 2022 and 15 July 2022 issued orders whereby the salaries of those teachers, salaries of the writ petitioners were stopped on the ground that their provincialization is contrary to the provisions of the Assam Education So-and-so Act 2017, as it has been found subsequently that the subject concurrence / affiliation were recorded after 1/1/2006. Stop. Since the impugned orders, the petitioners have submitted that they are working, rendering their services in their respective colleges without receiving any salaries. Stop. It is submitted that such an order passed by the director is contrary to the provisions of the Act, as the process for provincialization is a continuous process, and the authorities concerned had all submitted the necessary relevant documents prior to 2001-2006. However, the orders issued for concurrence by the government in respect of each of the colleges are after 1/1/2006. The learned counsel for the petitioners submits that once the provincialization order is issued, after due verification and of the relevant documents and the criteria required to be adhered to by the authorities concerned, the impugned order could not have been issued by the director, stopping their salaries. Stop. There is no provision under the Act of 2017. Are there any rules framed? No rules. And therefore, the impugned order dated so-and-so is arbitrary and is required to be suitably interfered with and set aside. Para. The respondents have filed their counter affidavit. The respondent, Director of Secondary Education, has filed their counter affidavit. Stop. Mr. R. Mozumdar, Learned Counsel for the Secondary Education, and Mr. R. Borpujari, Learned Counsel appearing for the Finance Department in WPC so-and-so and so-and-so, submits that there is no infirmity in the order of the director, inasmuch as it is the mandate of the Act, more particularly Section 3(2), which provides that the concurrence or the affiliation must be granted to the college prior to 1/1/2006. Stop. It is submitted that there is no dispute that the concurrence was not granted prior to 1/1/2006, as the pleadings in the writ petition reveal that the petitioners admit that the concurrence was granted after 1/1/2006. Therefore, the provincialization of the petitioners being contrary to the provisions of Section 3(2) of the so-and-so Act of 2017. There is no infirmity in the order passed by the director dated 30th of April 2022, whereby the salaries of the petitioners were stopped. Para-learned counsels for the parties have been heard, pleadings on record carefully perused, provisions of the so-and-so Act has also been perused. In the counter affidavit filed by the department, there is a categorical averment that the provincialization, that the concurrence in respect of the subjects pertaining to the in respect of the respective in respect of the subjects vis-a-vis the petitioners were received after 1/1/2006, and that being contrary to the provisions of the Act of 2017, the salaries, the petitioners are not entitled to their provincialized scale of pay, and therefore the salaries have been stopped, and the matter at present has been referred to the government seeking instructions for cancellation of the provincialization services of the petitioners. Stop. Although this affidavit was filed on 23rd November 2023, learned counsel for the department, as a secondary education department, submits that he has no instructions if the government has taken a decision in the matter in the meantime. The petitioners have also filed a rejoinder affidavit reiterating their contentions raised in the writ petition. Stop. While there is no quarrel with the mandate of the Act of 2017, that the concurrence, the recognition, etc., are required to be obtained by the concerned college, concerned institute prior to 1/1/2006. Fact remains that the orders passed by the petitioners or in favor of the petitioners have not been have been passed after due scrutiny at the various levels in the department. Stop. There is no averment in the affidavit that these orders were passed on the basis of documents which were falsified or incorrect. Stop. As such, the government is required to take a decision in the matter as to the status of the provincialization granted to the writ petitioners in terms of the provisions of the Act of 2017. Stop. The particulars of all the petitioners vis-a-vis the writ petitions filed by them and the subjects, along with the particulars of the school and the school concurrence and subsequent concurrence, are extracted below. Stop. Upon careful perusal of the provisions of the Act, it is seen that there is no provision for stoppage of salary by the director. Stop. Under Section 20, the power of interpretation and removal of difficulties is bestowed on the state government and whose decision is final. So, as has been stated in the affidavit, the matter is presently pending before the competent authority in the government, namely the Secretary to the Government of Assam, Department of Secondary Education. Stop. Upon during the course of hearing and upon perusal of the pleadings on record, it is seen that the concurrence which is stated to have been issued to the writ petitioners by, where is that concurrence order? Order dated 6th of May 2021 for the subject Advanced Hindi. You write in WPC number 7317 of 2022. Comma. This communication is stated to have been issued in continuation of the department's letter number so and so dated 31/3/2005, page 21. This communication number so and so dated 31st of March 2005 is the letter of government, is the communication of the government conveying the government concurrence to the director in respect of the petitioner school, namely Nelly Junior College. Stop. The subjects which are granted, subjects which are in which the concurrence has been granted is also specified therein. The subject of Hindi or Advanced Hindi, of course, is not mentioned in the said communication. What has not been disputed by the respondent authority is what has not been able to, what is not available before this court in spite of pleadings on record filed by the department is whether the application for seeking concurrence in respect of the subjects concerned, insofar as the writ petitioners are concerned, was put up before the authorities along with the subjects in which concurrence was received prior to 1/1/2006. Stop. In the absence of such specific instructions or materials before the court, it will not be conducive for the court to embark on a journey to find out and on this aspect of the matter. Such information is stated to be not available with the petitioners at this stage. Stop. However, since the concurrence has been granted by the government, it is expected that all these information are available in the government records, or the appropriate department can secure this information from the respective school authorities to verify whether the concurrence in respect of each of these petitioners, which are stated to have been issued after 1/1/2006, were in continuation of the concurrence which was issued in respect of the earlier subjects which were issued prior to 1/1/2006. Stop. Under such circumstances, considering that the petitioners have not been receiving their salary in view of the impugned order dated 30th April 2022 and 17 July 2022, this court is of the considered view that the matter should be disposed of at this stage with a specific direction to the secretary of the department, namely the respondent number 2, the secretary to the Government of Assam Education within bracket Secondary Department, to expeditiously consider the matter, expeditiously examine the matter and pass necessary orders. Stop. One submission was made by the Government Council during the course of the argument that the impugned order dated 30th of April 2022 read with the order of impugned order dated so and so stopping the salary read with the order dated 4th of February 2021, namely the order granting provincialization, comma, will mean that the services of the petitioners, the provincialization of the petitioners stood cancelled with effect from the date the impugned letter dated 30th of April 2022 was issued. Such submission is made by this Government Council by referring to clause 5 of the order dated 4th of February 2021, wherein it is stated that if any information is found incorrect or false at a later stage, the order of provincializations stand cancelled immediately. Stop. It will be within quotes or italics. Such interpretations ought to be given, cannot be accepted at this stage, as in view of the averments made by the director in their affidavit that the matter is presently pending before the government authorities, before the government, for specific instructions in respect of cancellation of the provincialization of the petitioner. Stop. Under such circumstances, the government is now required to examine and pass a speaking order in respect of each of these petitioners. Stop. If the order of provincialization was issued on the basis of correct documents and wherein it is reflected that the subject concurrence was received after 1/1/2006, then in the event the government takes a decision that their provincialization are to be cancelled, then the petitioners will have to be put to a proper notice before such cancellation orders are to be issued. Stop. The respondents cannot rely on clause 5 of the order dated 4th of February 2021 to arrive at a conclusion that the order of provincialization of the petitioners have been deemed to be cancelled. Stop. In the event the department finds that their provincialization cannot be is in contravention with the provisions of the Act, then the school management authority will be directed to pay the salaries of the petitioners and a fresh proposal for regularization of their a fresh proposal for seeking provincialization of the petitioners will be put up before the authority for necessary consideration. With the above observation, writ petition disposed of, the authorities are directed to examine the matter and pass a speaking order within 45 days from the date of receipt of a certified copy of this order. Any order that is passed, copies thereof will be furnished on the petitioners. That's all.
The salary. We are without salary.
We can see the difficulty is in the event they hold that you are not qualified, then this will amount to recovery.
We are serving Lordship. That working period they should pay.
It is made clear that upon due verification, if it is found that the petitioners have rendered services pursuant to their provincialization order, and if it is found that the provincialization orders were passed in favor of the petitioners, although the subject concerned received concurrence after 1/1/2006, and such order was passed without any fault on the part of the petitioners, then the petitioners shall not be debarred from receiving their salaries till the time they put in their services and till the time they put in their services. Okay.
Lordship, one direction will be to the Department of School Education, Your Lordship. Secretary.
Whatever is written here, school education. It's written as education secondary.
Lordship. But now it is.
What is it? School education. You write respondent so and so, Department of School Education, Department of Education, secondary as now renamed or reclassified as Department of School Education. Yes, disposed.
One place you have expected only 30th 4/2022 order.
34 and 15/7.
Another thing,
Have you mentioned in your chart which cases are 34 and which are 15/7? No, you give it in the chart. You put it in the chart, it'll be easier. That we'll see. Department of School Education. You put in the date of provincialization, just add a column in which matters it is, you just add the 15/7.
30th 4 and 57, whoever.
You hand it over to the court master. Dispose. Dispose. Part 2. What did you? Part 2, any matters? Unappealed part. Part 2. So, 3 day people are, they are not here. You're for the respondent.
Yes.
What is the status now?
Okay, I'm serving military.
As a district sports officer.
Yes. Only regarding my eligibility, there has been question here in the city. And according to me, I have filed affidavit, I am eligible, and that is why I was appointed. Even the PSC has also filed affidavit. They think that eligibility was there. That is why I was appointed. And already, I am serving for 15 years.
Who's for the petitioner?
After 15 years of service, a lot of change have been made to my life. At this stage, if eligibility on the basis of eligibility question, the
When was the selection held?
the
It may not survive. Is there anything 2007?
advertisement that was 2007. Annexure 1 page 10. Thereafter, a corrigendum was given by Annexure 2 2019, page 19. And by this corrigendum, the diploma of physical education from a recognized physical training institute. That was
You are an SC category. SC.
yes.
Petitioner is also SC.
Petitioner is not SC.
Then petitioner, who's for the petitioner? Council. Mr. Kuwar, I think.
Yes, well, there is no case at all, after 15 years, they
But
come.
you can inform him tomorrow, day after, we can take up the matter.
Yes.
He is available. Mr. D. Chaudhary appears for the private respondent. And Mr. You appear for the government?
No, finance is perfect.
And none appears for the petitioner on call. Matter will be called up next week.
On Tuesday next week.
No, we are not fixing. It's a hearing list.
Yes.
So it will remain in the list.
All.
You make a mention in court. If counsels are available, we'll take it up.
Much.
All right.